We are interrupting the hearing of Mr. July's evidence to enable me to deal with an application that was set down for 2 o'clock, that was brought by Judge Makubele for me to consider or consider amending a directive that I issued on Friday last week for her to file certain affidavits by Wednesday this week and to appear in person before me on Monday at 10 o'clock. Mr. Soni? Yes. Switch on your mic.
Chairperson, you will, as you've indicated on Friday last week, that's the 24th of July, you issued a directive, and the effect of the directive was that in respect of the affidavits filed by Mr. Ngoyi, Mr. Dingizwayo, Mr. Makashwa, and Mr. Ahmad, Judge Makubele was to have filed her answer, her response, by Wednesday, the 29th of July. DCJ, what happened thereafter is we received nothing on the 29th, but in the early hours of Thursday morning, that's the 30th, we received an affidavit together with annexures from Judge Makubele, but not from her attorneys. And that affidavit has been placed before you. Subsequently, we also received a notice of motion. The effect of that application read together with the notice of motion is that Judge Makubele requires that, or requests that the directive be varied, amended, if effectively not be in the terms that it is. And she asks that she be given until the 3rd of August to file her responding affidavit, and that she only appear on the 8th of August before you, Chairperson. That is the application that she filed. The Commission filed a responding affidavit in which we opposed the application. I just point out...
Basically, the legal team of the Commission filed...
I beg your pardon, it was a legal team. Basically, may I just point out, DCJ, just for record purposes, Judge Makubele's affidavit was 77 pages long. Our affidavit is 5 pages long, and we say that she didn't really address the issue before that she should have issued, namely, on what basis is she seeking a variation of the order that, or the directive that was granted last week. And so we persist in our opposition to the relief that she seeks.
Is there appearance for her, or is she here?
DCJ, what happened, Chairperson, what happened next is that after we filed our affidavit, after the legal team filed its affidavit, which was served on the attorney and Judge Makubele, we didn't hear anything from them until about 10 o'clock this morning, when we received an email from the attorneys saying that they were withdrawing as attorneys of record for Judge Makubele. We then communicated with them telephonically to say that they should, given the lateness of the hour, they should formally seek your leave before they withdrew. They phoned about 15 minutes ago to say that their counsel is otherwise engaged, their junior counsel is not available, and they are unable to attend. So that is the position. The Secretariat also phoned Judge Makubele about half an hour ago, informing her of the fact that her attorneys had withdrawn, and her approach was that she could not expect to be here. So effectively, in answer to your question, DCJ, there is no appearance in support of the application, and what you have is simply an application on paper with nobody motivating why the relief she seeks, which is quite far-reaching, should be granted.
Well, I did read Judge Makubela's affidavit. You said it was 77 pages.
It is.
But I think you meant with the annexures.
Without the annexures. So the affidavit itself is.
The affidavit without the annexures is 47 pages.
I beg your pardon, it's 47 pages.
Yes, and then there are annexures. So at this stage, we don't know whether she could be available at any stage later this afternoon, assuming that she could not be here because she was involved in some matter in court, or because she had expected her lawyers to be here. One doesn't know when she might have got to know that the lawyers withdrew.
Yes.
We don't know that.
No,
Yeah.
Chairperson.
Well, in court, what one would do is strike the matter off the roll.
Indeed.
Think that what we'll do is that I propose not to I propose to deal with this matter in this way. One, not to change anything in the directive. I do not, not to change anything in the directive at this stage. And unless I decide otherwise, the position would remain being that the directive issued on Friday stands, which means on Monday, Judge Makubela must appear here. Now, when I read her affidavit, she makes it clear that on Monday, the Judge President has released her from her work commitments, and actually for the rest of the week. So she is available on Monday, but she was asking that she be given a chance to file the affidavits that she should have filed on Wednesday, to get a chance to file them on Monday. And she wanted that we move the date for her appearance to Friday. But in the affidavits, she doesn't give any reason why, if she files her affidavits on Monday, why the evidence should only be heard on Friday. If I recall correctly, her counsel had indicated last Friday that she was undertaking to file her affidavits by end of this week.
But today.
Yeah. The directive said she must file on Wednesday. So one would have expected that she would have been able to meet her own deadline that she had undertaken. It seems to me that if one has regard to the fact that she has had these affidavits on the basis of which she will be asked questions, she has had some of them for the past 6 months, and the last batch is of only 2 that she has had for 2 months. She would have had enough time to familiarize herself with all the issues. I think that the position that will remain will be that she must come on Monday, then if she has got her affidavits when she comes, then the question of whether or not she had sufficient cause or a proper explanation for not having filed them on Wednesday is a matter that can be dealt with then or thereafter, depending on what I direct. So the affidavit that she has filed can still be used by her to seek to justify why she was not able to file the affidavits on Wednesday. But she will have been prepared by then. And if she doesn't have the affidavits by 10 o'clock, that doesn't mean her evidence cannot be heard. She can give her evidence, she can be questioned. It may well be that when she makes her affidavits available, whether before Monday or on Monday morning, it may be that the legal team of the Commission might take a view that they need time before the matter can proceed. But it may well be that the legal team would be able to proceed, maybe needing an hour or even 2 hours to look at those affidavits, and then we can proceed. So I think what we'll do is postpone this application to Monday, but the directive issued in terms of Regulation 10.6 of the regulations of the Commission, issued last Friday, will stand in the meantime. If on Monday, we were able to proceed, we should proceed. So briefly then, this application is postponed to Monday. That's number one. Number two, in the interim, and unless I decide otherwise, between now and Monday, the directive issued in terms of Regulation 10.6 of the regulations of this commission on Friday last week stand, and Judge Makubela must appear in person before the commission at 10 o'clock. And I think it will be important that this be communicated to her.
Yes.
Okay. Thank you.
As you please, Chairperson, and
Thank
we
you.
appreciate being accommodated in the middle of the evidence of
Yes,
Mr. July.
yes, no, thank you. You are excused,
As you please.
and then we can continue with Mr. July's evidence. Sorry. Okay, are we ready?
Thank you, Mr. Chair. We were still discussing the question of the defeating the ends of justice, how you had come there, you had dealt with that, Mr. July. And what we were examining was, towards the tail end of that, we were examining the question of what you regarded as being what they had done wrong. If I understood your evidence correctly, and please do correct me if I'm wrong, but if I understood your evidence correctly, what you in essence saying is that if they didn't express their honest opinion on the content of the docket, in other words, they didn't capture the content of the docket accurately, in order to absolve somebody, that would amount to defeating the ends of justice. So if I understand your argument correctly, there's two elements to it. The one is the failure to capture the content of the docket accurately, and the second is an intention to do so in order to absolve somebody from liability.
Yes, that's mine.
Now, and if I understand your argument correctly, what you're saying is that in the present case, in relation to Mr. McBride, Sissoko, and Kuba, that's precisely what they appear to have done, and that's why you recommended that they should be charged.
Yes, prima facie, that's what we found. And then we found prima facie that they have committed they defeated the ends of justice. And of course, when we do the so, Chair, the NPA will have to take over from there. And the report was to the minister. It was not to the NPA. So once the NPA decides that, no, these guys, there is this prima facie view, then they must do their own investigation. That's, yeah.
No, fair enough. So just to understand correctly, what, insofar as the present case is concerned, the report that they had compiled, they had obviously come to the conclusion, at least in your mind, as expressed in the second report, which was the report of the 18th of March of 2014. That report differed with the report of the 22nd of January 2014. And it was not the fact that they had a different opinion. It was the fact that they had a different opinion because, in your view, they dishonestly removed information from what was contained in the first report.
Of course, it was not just a matter of opinion, but the opinion is to be taken into account what informed the changing of the opinion. Not then just the changing, but what informed the changing of the opinion.
Yes.
So if you were to change...
That is the reason for changing.
Yes,
That's what you
the
talked
reason for
about earlier
changing,
on, yeah.
yes. That's critical.
And of course, you're not suggesting that only Mr. Kuba was guilty, because he held one view, one in respect of the first opinion, but a different view in respect of the second. You suggesting that any person, including Mr. McBride and Mr. Sissoko, if they had expressed the opinion that's contained in the second report, that in itself was sufficient to make them liable for defeating the ends of justice.
Yes. We say so, Chair, because if you look at, if we are right that the information is deleted, and you want to know who deleted the information, Kuba doesn't know. He says, I don't know. What I do know is that I worked on my analysis. You ask Sissoko. Sissoko said, I've never seen that kind of a report. You go to McBride. McBride says, I've never seen that report. But there's a common factor, which is all of them, they looked in the information, the analysis of the evidence. And they come to the conclusion. So if 3 people were in possession, which, Chair, maybe it will be easier if I can explain whether indeed McBride was right to say he has never seen the report. It is not true that he did not see the report. We came to the conclusion that he saw the report. Sissoko, it's not true that he did not see the report. We came to that conclusion that he saw it. McBride, why? We came to that conclusion. You will note that on the 3rd, when McBride started, the evidence is that McBride asks Sissoko that he wants the update. And in fact, when we questioned Kuba, it is very specific. He wanted the report, not the update. And then Kuba emailed the report to Sissoko. Sissoko prints the report and gives it to McBride. It is on record that Sissoko printed the report. But you will see somewhere the version changes again and say, no, I've never seen the first report. But he forgets that, Sissoko, that when Kuba emailed the report, he emailed to Sissoko, Sissoko printed it. It's on the record when we interviewed him. And he gave it to McBride. And when Kuba came the following day, because there was a meeting that was suggested, that there must be a meeting the following day, Kuba says, when I met McBride, it was a person who knew what was in the report. And we asked a specific question. The report that you gave to McBride, is it the same report that you filed with the NPA? Because you filed a hard copy. He said, yes, unequivocally, yes. It was the same report, but it was a soft copy, right? So even the questions that he was asking, you could tell, that's what Kuba now says, that is the person who read the report. So one of the issues, for instance, was the involvement of crime intelligence. You'll get conflicting versions as to who raised that issue. Kuba says, McBride asked me, why did we involve crime intelligence? But Kuba says here, it comes here. He says, no. When I got there, I told McBride, when I was briefing him, that crime intelligence was involved. And McBride got concerned. But that's not what he told us. There's a difference in most issues that Kuba said here and what he said to us in preparation of the report. Depending on finding out how much do you know then Kuba will tell you what he thinks you must know. So that's the problem that we are faced with. So you have, in our conclusion, 3 people who were in possession of the report who don't want to acknowledge the existence of the report, 2 of them. Then 3 of them, all of them, they don't want to acknowledge the deletion. If that deletion was innocent, why can't you? Why can't you say, yes, we deleted? Because you can't delete evidence.
Well, you are right in saying when asked if they had seen the report, that is Mr. Sissogo and Mr. McBride, if in fact they had seen the report, but they deny having seen the report, you have to inquire, why are they denying
it?
Having seen the report when in fact they have seen the report? Now, I'm just looking at it from your angle.
Yes.
To say it's legitimate to ask that question.
Yes.
If, as a matter of fact, you are convinced that they saw the report, but they are denying that, because the denial could throw light on something.
Yes.
To say, if the leaving aside whether or not, the question of whether or not putting their summary or analysis the way they did in the second report, whether it amounts to defeating the ends of justice or anything like that, what would be legitimate is to say, if they had seen the report, one would expect them to acknowledge that they had seen the report. And if they had changed the analysis or summary because of an acceptable reason, one would expect that they would give that reason openly.
Yes.
So that part, I think, is legitimate to look at it that way. But of course, a very important part is the one about whether, when they said they had not seen the report, that's Mrs. Sogo and Mr. McBride, whether that was actually true. Okay.
Thank you, Mr. Chair. Now, just to clear up one issue, you've referred interchangeably to deleting information and deleting evidence. To be fair, there was no evidence that was deleted. There was information, or rather a recordal of what was in the docket that was removed.
That's semantics, Chair. Because if I say to you, like I said, I was here on the 31st of July, 2020, and that 31st of July, 2020 is not recorded in your report because it is an important date for you to come to a particular conclusion that Sandile indeed on that day, then that's a deletion of the evidence which was already in the report. You remember, the evidence is what you are being told. It can be verbal, it can be in writing. And when you take that evidence, you put it in your report, it doesn't change its nature. It's just that is in another form, in the form of a report. So I'm not suggesting that they erased what was the physical statement. No, I'm not saying that. But that evidence was imported to the report, and now it is deleted. That is what I'm saying.
Yeah, I think that what Mr. Halley raises is something that also I was looking at when they were giving evidence, and which I think is important, particularly because the charge, as I recall, said they altered And I think your report was also based on saying the whole issue is about the alteration of the report.
Yes.
Yeah. Now, if two people are given the same material, let us say statements in a docket, and they are asked separately and not in collaboration with each other to prepare a report based on those statements, they are likely to come up with two different reports that might have the same substance. But the wording obviously would be different, you know, how each one is not going to be identical, because then once it's identical, they must have copied. One must have copied from the other, or maybe through some technology, it might be done without copying. But, but you might have this one person whose report you look at and say, but this is not an accurate summary of these statements. I've looked at the statements, I've read them. This leaves out some important parts. So I'm unhappy about it because of that. And then there is this other one, you have read the statement, you say, this is the one that really accurately summarizes what's in the statements, okay? Now, if the first one, whose report you find not to be satisfactory, didn't see the other report, I expect that all you would say is, he's not good at summarizing things or something like that, you know. But you might not think of anything else, you know. And this one whose report you are happy with, you might say he's good at making sure that his summary contains all the important information. So, therefore, one asks one the question whether the moment we all accept that this alteration did not entail physically changing anything in the statements, whether we are not dealing with a situation where, while Mr. Kuba was without Mr. Sisogo's contribution and Mr. McBride's contribution to the first report, and with the contribution of whoever may have contributed to the first report, he summarized and analyzed the statements in a certain way. But once there were three people now working on the second report, they are bound to have different views and they are bound to attach different amounts of weight on different aspects. Whether you're not dealing with that kind of situation, because now there are three people who are all going to sign this report, whereas the other one, only one person is going to sign it, even though he has contributions from Mr. Mosing and somebody else. So there is that.
You know,
Well, what do you say?
yeah, if under ordinary circumstances,
Yes,
Chair, I agree with you.
Yes, yes.
But here you have a situation
Yes.
first where there's a denial of even having seen
Yes,
the
yes,
report.
yes.
But that report looks exactly
Yes.
with the same report that was not seen.
Yes.
That creates a problem.
So would I be right in saying what really changes or changed or influenced the way you saw the matter was that you believed that Sisogo and McBride had seen the first report? That's what.
That's exactly what.
Yes.
Yes.
Okay.
Thank you, Mr. Chair. Now, of course, you had consulted, interviewed Mr. Sissoko, you had interviewed Mr. Kuba, you had interviewed Mr. McBride. Would it be, is that correct?
Yes, I interviewed her.
Would it be fair to say that Mr. Kuba informed you that he had never been instructed to exonerate anybody? He had never been instructed by Mr. McBride to exonerate anybody. Would that be fair to say?
Mr. Chair, he says McBride did not expressly said I must change the report. But he says in the same breath, it was due to the influence of McBride. He would not have changed the report. He says that. He says, I told Sissoko, I said all what I needed to do was just to go and attach the information that I received. There's no need for picking up the docket. That's what he says. And we come then to the conclusion that you think that McBride is going to expressly say that. He doesn't have to. He doesn't have to. It is the conduct that speaks for itself.
Of course, there is nothing, there would ordinarily be nothing wrong with Mr. McBride influencing Mr. Sissoko,
Yes.
Mr. Kuba as to certain parts of the report.
Yes, yes, that's true.
It's as long as he was not forcing him to do something dishonest or something like that, as long as it was within legitimate bounds. But I guess that what your view was that it was not within legitimate bounds.
It was not.
Yes.
It was not.
You are saying that he wanted the report to exonerate General Dramat.
Yes, and severe.
Yeah.
He even goes further, Chair, and say, I became happy when my boss was happy.
Yeah.
He says that. He's on record, saying, I became happy when my boss was happy because this report was making me sleepless nights. It was to and fro until Sissoko said to me, the boss is happy. Then I became happy.
But of course, doesn't Mr. Kuba somewhere say that he was not aware of the so-called deletions?
Not
Does
aware-
Mr. Kuba did he not at some stage say to you during the interviews that you had with him, did he not at some stage deny having been aware of some of the changes?
Yes, he did.
Yes.
The only thing that he touched on was the analysis.
Yeah.
He said, having been influenced, Sissoko being a lawyer, Sissoko who did law, I was now influenced by Sissoko. But that also is problematic because that very debate with Sissoko, he told us that it took place before McBride came into picture. But he was never convinced by Sissoko. He was never convinced because he believed that General Dramat went to Zimbabwe on the 5th of August, 2010, to attend a meeting of the region. Then on the 6th, he had a side meeting with the Zimbabwean police. And the issue of the fugitives was discussed in that meeting. After that, they agreed to meet after 3 months. Now, 3 months, if you count 3 months from August to November, to November the 5th. They meet on the 5th of August, 6th of August. It's exactly 3 months when they come here on the 4th of November. And so, Chair, when you come here on the 4th of November, it is what happens then, now, when they were at the Bay Bridge. That information is critical. If you remove that information, where Matilongwe says, I then called, you then say it doesn't matter even if you called, but we don't know what he was talking about. That is fine, that's your analysis. But don't put it as if that call did not happen.
Well, what is the factual basis for you not accepting that in summarizing the evidence or summarizing the statements or analyzing the statements in the way in which they did in the second report reflected their honest opinion? Because I may be asking you in a different way what Mr. Hali might have asked earlier on, because I take it that you would accept that provided they, in making the changes, they were acting honestly, even if wrongly. If they were acting honestly, then there would be no defeating, they would not be said to be guilty of defeating the ends of justice. So what is the factual basis for you not to accept that these changes they put in the second report were put in honestly, even if, in your view, wrongly?
The one thing, Chair, starts with the retrieval. It starts with the retrieval of the docket itself.
Yes.
Right. That's where it starts. Then now you have the report. You deny that you have seen this report. But this report has been changed. You don't want to accept that you have changed the report. You say all what was changed is the analysis. Nobody owns up on the deletion. Nobody owns up on the deletion of the other part. Everybody talks about the analysis. When we realize that the evidence was unsustainable, the unsustainable evidence must be left there. Yes.
Would this not have been a situation where, if you are convinced that the recommendation that General Dramat should be charged is correct, you need to have this information, because then it will link?
Yes.
But the moment you are convinced that that conclusion, that recommendation is wrong, is not justified,
Yes.
then that information it doesn't make much sense, because now it was there to show that this recommendation is justified. But if you have changed the recommendation, that information doesn't make sense.
You must deal with the information.
Is it not that situation?
No, it's the situation, Chair.
Yeah.
I hear what you're talking. You're talking about an ordinary situation. You are being general. I'm saying we took a lot of things into account. To come to that conclusion. It was not just a question of deletion. We started from the fact that McBride had no reason to ask for the docket, or even for the docket to be collected in the first place. The second one is that there is no reason for McBride to sign the docket. Nothing in law. Yes, he's not breaching the law by doing that. But he takes it and comes and say to you, it's because the law requires him to sign. That docket, that report was irregularly given to NPA because it lacked signatures of two people, the head of investigations and him being the executive director. He then justified that by saying in section 7.4 of the IPID, the executive director has got powers to sign, is required to sign the report, which is the reason why that report of Kuba was not a report in accordance to the prescripts of the NPA. So we took all those things into account to say, why should we be lied to? Because he had no reason. He had no business with this report. And again, this is the person who said has never seen the report. So I'm trying to also demonstrate the inconsistencies in the evidence.
There was a, I don't know whether it's a Regulation 5, there seems to be a reference to a report being approved by the Executive Director, but I think I got that from your report, if I'm not mistaken, and it didn't seem to be complete. In terms of the Act and the regulations, is such a report not required to be approved by the Executive Director?
No.
What is the reference to approval, as you understand it? What does it refer to that I'm talking about?
Okay. Where we need to start then, Chair, we need to start what was the nature of this investigation. Because all of them are categorized in terms of Section 28. It says, even Kuba in his report does say it is 28F and H, right? The H part is the part which says it was referred. But the question is who referred it? Kuba tells us in his report that it was referred by the Secretariat. To do what? To investigate. Because Koboshiane made a report in June 2012 where the investigation was done on this issue. But he said, this is bigger than us. We don't have investigative capacity. So we proposed two things. One, we proposed that Judge Pillay, who at one stage sat as a, I don't know to do what, at the DPCI, must sit and look at the matter and come to a conclusion on this matter. Alternatively, let's take this matter to IPID to investigate to do criminal investigation. Because what has been told to Parliament, it's lies. He concludes that. Then this report is then taken on the basis of Koboshiane, which is the Secretariat, is given to IPID. That's 28H. But what does the 28H say? When you receive a report that has been referred by either the MEC Secretariat, you then use Regulation 7, right? When you go to Regulation 7 says for you to be able to deal with this investigation, you must first determine the nature of the offense committed. The offenses are contained in Regulation 4 and 5. In fact, those regulations in 4 and 5 are the same offenses that are in Section 28A to 28G. Then 28 of the Act, 28A and B, deals with the murder, the killing of people as a result of the action by the police, right? So both A and B cover the murder. So what then happened is that when you look at 4, within 4 you find two scenarios. Where the commission of murder happens immediately, where IPID can go and do the scene inspection. That's 4.
But remember, I'm just looking at approval. What is your understanding of whether approval is required at any stage?
It's not required. Nowhere.
Yeah, that reference to approval that I'm talking about, you know what I'm talking about in Regulation 5?
Regulation 5. I don't know.
I thought I got it from the Werksmans report, but it was not.
I know we do make reference to Section 5.
Well, because I've got the report in front of me, if I'm right in saying, I must have seen it. Yes, it is at page 127 of the bundle. You say there's paragraph 14 of the report itself, Regulation 5, Roman figure 1 to the Act states, after collecting all evidence, statements, and technical or expert reports, if applicable, submit a report on the investigation of the offense to the Executive Director or the relevant provincial head, as the case may be, containing recommendations regarding further action, which may include disciplinary measures to be taken against a member of the South African police service or the municipal police service or criminal prosecution of such member. It says, so maybe there is no approval as such, but it says submit a report on the investigation of the offense to the executive director.
Yes.
Yeah.
Yes.
Would that apply to this
No.
this report, or
No.
if not, why would it not
No,
apply?
it does not apply to this.
Yeah,
request.
why not?
It does not apply, Chair, because Regulation 5 deals with issues of assault.
Oh, okay.
Regulation 5 is
But wasn't there
strictly-
assault in this rendition?
There
thing?
was an assault. Chair,
Yes.
but the issues of assault, when they dealt with,
Yeah.
it was the emphasis was on the murder part.
Yeah.
So because you have two, you have the assault, you have murder. Of course, murder comes number one. And when McBride was asked here by Mr. Advocate Paul Pretorius, you can look at the record, it starts from the investigation that was done was about murder. Because that was the issue. It was even the issue that was raised by Parliament, that why were those people killed? And the specific question was asked, was Dramat or Sibia involved in this rendition? So the real section which was used was the fact that it was murder.
Okay. Ms. Halley?
Thank you, Mr. Chair. Just to get back to what you were asking, what I was asking you about previously and what you testified on, you were testifying that Mr. McBride had put pressure on or had influenced Mr. Kuba to change the report. I was just trying to listen, and you were looking in the direction of the,
Yes.
of the chairperson, but I didn't catch. What was the influence? I know you said that at one stage he was very happy.
Yes.
But what was the influence by Mr. McBride?
No. Kuba says, I took the docket. Then after taking the docket, I went straight to McBride, right? And then from McBride, I went to the office
Yes.
with Sissoko. Then he says, we opened the report. Then the three of them worked on the report, right? So he then says, that I was influenced, that the report was influenced. I asked the question, would this report have changed if Mr. McBride did not require you to relook at the report? Kuba's statement is no, it would not have changed. And I asked a question, this information that you say was outstanding, these warning statements that you are talking about, what impact did they have in the report? He says none.
No, but I think we might be talking at cross purposes. Tell me, what is it that Mr. McBride did?
No.
Did he put an iron on his hand?
No.
Did he threaten him with a gun? What was that act that he did?
This is what Kuba says, that he was influenced by McBride.
You
What
never
would
got to know how he
We didn't
influenced
know.
him. Yeah.
We didn't. You remember, Chair, what we asked, we look at the totality of this. Why Kuba suddenly say he wants now to go and collect the docket, right? He comes back with the docket, right? And then they look at the evidence, the same evidence that he looked at when he submitted it, the same arguments that were raised by Sissoko, because this issue of the analysis was there even before the existence of the document. Suddenly, that evidence, that analysis becomes critical. And can I say this, Chair? And I'm saying this in my affidavit. We had a number, if not about 3, of record talks with Kuba. And one of the things, and he even mentioned it himself in the transcript. He says, you remember what I said to you off the record. If you were to ask me, is this person suitable for this position? I reserve my comments for that. But the other things that he said off the record, was that he was scared of McBride. And he was scared of McBride, and he said many things, Chair. Some of them I don't even remember, but he did say that he was scared of McBride. Then he talks about the political history, his history, and all of that, and says afraid of him. So when he says, don't take it lightly, when a person says, when he say is happy, I was happy. So the influence, sometimes, you don't have to tell a person. A person formulates a view, whether that him being scared of McBride was justified, we don't know. But he said that. But of course, he did not say those things on record. And we do say that in our affidavit.
Now, you've said that in your affidavit. Yes. What I want to understand, so according to him, he was afraid of McBride. This is off the record discussion. According to him, he was afraid of McBride. As I understand correctly, reading your affidavit, he was afraid of him because of his struggle credentials.
Yes.
Now, he didn't say that he was afraid for his physical well-being, if I understand correctly.
No. You can't just be afraid of a person you will be afraid of Nelson Mandela then.
Pardon me?
I'm saying struggle credentials only. That's not what was communicated to us, Chair. It was a person who is scared of this person. We don't know what he said to him. We didn't bother because that's not what we were there for. But we could take that, what he said off the record. Because what he said off the record, Chair, I would request that you give you time, you read how his evidence, when we interviewed him, his narration keeps on changing. You will see that at some point he wants to tell the truth. At some point he remembers that my boss told me the following, right? Because there is no doubt, you can tell that they must have met somewhere. And the issue of the docket or the report McBride not having seen was discussed. Remember, we're dealing with 2015. We are dealing with this thing in 2015 when the changes have already occurred. The changes have already occurred in 2014. Now they must come and explain why the changes. The first thing would be from McBride's side, I've never seen the report. As a result, during the interview, we did not even discuss the second report, the first report with McBride. So the Kuba's being scared of McBride, we spoke to Kuba. We had the benefit of looking at Kuba. And we believed him. We believed him that he was scared of him.
Now, just to round off that particular theme, you spoke to Mr. Sissoko as well, and Mr. Sissoko, he said that Mr. McBride had not instructed them or had not given them any indication that they are to amend the report in any way.
No.
Would that be fair?
No. You see, Sissoko, I hope you have gone through the Sissoko's
you have lowered your voice and you are away from the mic.
I hope you have gone through the Sissoko's transcript. Sissoko was a very difficult person of all the people that we interviewed. Difficult. He was, even where he agrees with you, the difficult that we also had, you will see where Sissoko is caught up. You will use So you don't know whether he's agreeing or is acknowledging what you are saying. And I ended up even saying, we are not going to waste our time with Sissoko. So we need to proceed. So anybody who thinks that McBride would have told them that let's change the report, that's not going to happen. Let's change the report because I want to achieve a particular goal. It is the conduct You look at the conduct and what has happened, and we came to the conclusion. Yes.
But of course, I go back to what we discussed earlier, and I raised with the minister as well. All of these 3 iPad persons, as I understand the positions, were people with quite some experience in investigation. Is that not so?
I'm not sure about that, Chair.
Yeah.
I'm not sure
well,
about that.
That's my understanding. Not that I know anything. Yes. You are not sure about that.
I'm not sure about that.
Okay.
I'm not sure about this experience of investigation.
Yes.
But whether Kuba was an investigator, yes.
Yes.
Remember the history of IP, it is ICD.
Yeah.
There was not investigation at ICD
Okay.
because ICD was housed within the
Yes.
police.
Yes.
So
What I'm looking at
Yes.
is certainly Kuba gave in his statements, talked about the history of the 2 organizations.
Yes, yes,
Yeah,
yes.
he talked about that. And then, of course, he was in charge of Limpopo, is that right? Under IP,
yes,
he was in
yes.
charge of Limpopo.
Yes.
My understanding is that being in charge of Limpopo would mean that he was in charge of also provincial investigations in Limpopo falling under IPID. Would that not be correct?
No. Chair, that's another issue about. I'm saying, Chair, the issue of Kuba and the position that he was holding as a provincial head
Yes.
before IPID.
No.
Well, yes.
talking
Of course, he had some experience, but I
Yes.
dispute this thing because
Yeah.
I heard you, Chair, that same comment
Yes.
when Nhleko, Mr.
Yes,
Nhleko was
yes,
here.
yes,
You
yes.
made that comment. You said,
Yes.
these guys are very experienced.
Yes.
And
No, I take it that they're experienced, but you have to say, look, on what you know,
Yes.
you don't think
No, they're
they
not.
all have that experience or whatever.
They don't.
Yeah,
Kuba
so what is
might
your
have.
experience? What's your understanding about their investigative experience?
Kuba was
Yeah,
an
just talk
investigator.
one by one, yeah.
Kuba was an investigator.
Yeah,
Sissoko was not an investigator.
he was a,
And he was never a head of investigations. If you look, Chair,
there's a question of acting head or what?
Chair, there are 4 units
Yeah,
that fall at the head office. 4. One of them is the office of the executive director. The other one is corporate services unit. The third one is investigations and information management unit. The last one is the legal services unit. Sissoko was appointed to act as a head of investigations and information unit. That unit, all what it does is administrative. You come up with all things that have to do with investigation, and if its investigation is completed, you take the report, which comes from the provinces, you summarize it for the executive director, and for the executive director to go to the minister. He was never the head. If you look to at the SOPs, the head of investigations reside at the provinces.
I thought there was a head of, as I understood it, national investigations.
No. That's a unit, Chair, which
That's
is
a unit.
purely administrative.
Yes, but there is a unit called
There is
that.
a unit called investigations because your SOPs
Yes.
will also come from that unit.
Okay,
Right?
okay.
And how do we conduct investigations and all those things. But the report, the person who has the final say on the report, there are 2 people in terms of the act. Now I'm talking the act. Is provincial head or the
The executive
director investigations.
Okay.
Those are the only two.
Now, who was the director investigations at the time when this second report was done? As you understood then the position, if you do.
Yes, the investigation the director investigation was Kuba.
Okay,
He was also a provincial head.
yes,
He was wearing two hats.
okay.
This is what happened, Chair.
Okay.
The complaint comes to the head office. In terms of section, I think it's section 2. Yeah, I think section 2 or 5. I think it's 2, which says once you receive at the head office, you receive this complaint, then you must determine which province, the relevant province. The reason why it was given to Mr. Kuba is because Mr. Kuba, the issue was about baked bridge.
Yeah.
Because the rendition, the handing over of the Zimbabweans happened in Limpopo. That is the reason. But there's a question there of appointment and who appoints the investigator. There is no such, the investigator is appointed by the executive director. In this case, Kuba would have been appointed by Mr. Werksmans, who was there in 2012, right? But that's the first appointment, appointing him as an investigator.
Okay, but going back to the issue I raised, so what you are saying is, you are saying Mr. Sissoko may have been executive, may have been director investigations, but that doesn't necessarily mean he had investigative experience.
No, yes, let me tell you why.
Or a lot of it.
Yes.
Yeah.
How Sissoko becomes, as I understand, Kukimbeki would come and testify. I don't know why he has not been here yet, because all these things could have been sorted out. How I understand is that the position of provincial heads under ICD, when they did whatever they did in terms of evaluations and the changing of the act, that position was higher than the position that Kuba and Sissoko used to occupy. And then because of the act, they had to take the positions that are immediately below the provincial heads. Because they did not qualify, I'm told, for the position of provincial heads. They then got appointed, not even appointed, they were confirmed because they were already in the system as director investigations, right? So the position of Sissoko, without even having investigated anything, was then with that of director investigations, but appointed to act in the position of in the unit, which is called Investigations and Informations Unit. But it's not called head, it's called Program Manager.
Okay.
I think we need to get that terminology clear.
Okay.
It's not the head. There's no such thing as head of investigations and information unit. You've got a program manager.
But in their evidence, didn't they refer to head of national investigations?
Yes.
They did.
They called him a head.
Yes.
They said he
You
was a
see,
head.
When people who come from that organization use that terminology,
Yes.
You understand.
Yes.
Yeah.
No, they
Okay.
did. They did.
Thank you. Let's proceed.
Thank you, Mr. Chair.
We are at 3:10 on my watch.
We're making very slow progress, Mr. Chair. I say we're making very slow progress.
Well, I can tell you that in terms of what I am interested in, we've made a lot of progress.
Yes, but in terms of the 2.5 hours that I had estimated, we're way beyond that.
Well, we may be, we certainly are way beyond that, but what Mr. July has dealt with since this morning covers quite a substantial part of the matters that I have identified as
Absolutely.
those matters that I'm really interested in. But there may be others that we have picked up which I might not have picked up.
I've dealt with Mr. Kuba, I've dealt with Mr. Sissoko. If I understand correctly, Mr. Kuba felt that he was pressurized into changing the report. He hasn't identified specifically, but you know that he was afraid, so that deals with Mr. Kuba. Insofar as Mr. Sissoko is concerned, he too indicated that he had not been pressurized or that there was no instruction from Mr. McBride to change the report, but you're not satisfied. You dismiss what he says because he changes his, sorry.
I think you think that I made that recommendation because they were influenced by McBride. No. I'm not saying Sissoko should have been influenced by McBride. I'm saying they were all participants. Whether influenced or not, at the end of the day, you take a decision to be party to that. So Sissoko does not have to be influenced. No, Kuba does have to be influenced.
The only point I'm making is that between the two of them, and I've dealt with two people, dealt with Mr. Kuba, we've parked him. Dealing now with Mr. Sissoko, I understand that in your interview with him, he had indicated that he had not been pressurized, there had been no pressure brought to bear upon them to change the report in any way by Mr. McBride.
You remember, Sissoko denied even having seen the report, so he can't even say I was not influenced by McBride to change the report because he denies the existence of that report. He said he has never seen it.
Okay, let's do it slightly different.
Yes.
Would it be fair to say from your interview with Mr. Sissoko that he denied that Mr. McBride had brought pressure to bear upon him or upon Mr. Kuba to exonerate anybody? Would that be fair?
No. I don't remember anything which has to do with influence because we could not ask such a question. Because Sissoko, although at first he said he received the report from Kuba and made a copy and gave it to McBride, he later denied the existence of the report. And from there, he was consistent. Even the papers that he filed in court, he denied, but he contradicted himself because he also accepted that on the 23rd of January 2014, he was given a report to prepare it for the Secretariat. So I don't recall anywhere where Sissoko will have to deny having been influenced by McBride because he didn't know
Not to change
anything
the
about
report. I've changed that because of your statement.
Yes.
To exonerate anybody. That's my question.
No, even that one.
Just put the full
Even
question.
that one.
So the proposition is, or the question at least is, was it discussed with Mr. Sissoko whether Mr. McBride had put pressure on either him or Mr. Kuba to exonerate anybody? For him to understand or to answer that question, does it require him to acknowledge the pre-existence of another report? It simply deals with whether he's required to exonerate somebody in this report.
No, you see, we would, on what basis would we have asked that question if he says he doesn't know anything about the first report?
Then, now, if I understood your testimony, and I am touching on something that I've dealt with before, the essence of your complaint and why the conduct might amount to defeating the ends of justice relates to the importance of this report and the fact that it's so important that it has to be taken seriously in terms of the IPID Act, in terms of the regulations, and in terms of the standard operating procedures.
Not only that, it's because that report is in terms of the Act. Section 28, that's the core of IPID. The core mandate of IPID is to produce the reports. They do the investigation. They don't just investigate and say, okay, we have investigated. They investigate, and then they must make reports. And those reports will say, prosecute. And if you say person must not be prosecuted, you are defeating the ends of justice if I were to find that you did something to influence that decision.
Just remember, Mr. Halley, that what I said earlier on, that the commission is not to assess the correctness or otherwise.
Indeed, Mr. Chair, and I'm
his
mindful of that.
conclusions. Actually, if you like, you can ask questions that are based on assuming that his report, his conclusions were wrong.
Yes, we're not entirely concerned with that.
You know, so if you want to approach it, you can approach it that way. But you know, the commission is not about whether his conclusions are wrong, but it's looking to see whether there is any evidence suggesting that there was some other agenda about
Of course, Mr.
about the investigation.
Thank you, Mr. Chair.
and the report, or whether they improperly enabled the maybe, for lack of a better word, harassment of persons who stood, who were against corruption and who wanted to do
Thank you, Mr. Chair.
the right thing.
Can I, on that comment, Chair, I know it's not a question, you're
Yes,
making a
yes.
comment.
Yes.
And you're making a comment that whether our report could have been used for, or we assisted in our report
Yeah.
to fulfill
To
the
further.
ulterior motives
Yes.
of other people.
Yes.
Chair, if our report, which is based on facts, is then used by somebody
Yes.
who has an ulterior motive,
There's nothing
that
you
has
can do
nothing
about
to do
that.
with us.
Yes. Yeah.
that
Yeah.
has nothing to do with us.
Yeah. Yeah.
What the argument or the answer that you've given in relation to the importance of the report, it certainly, of course, is a very important argument that's raised in your affidavit. But I must confess, I've searched through your report to look for that argument, and I don't see it in the report, that it was because of the importance from a legal perspective. Now, I might be wrong, but if you would like to refer to report, deal with that issue.
The fact that we don't mention it, it doesn't mean that we didn't consider it.
Sure.
We
But
may
it would
not
be-
have mentioned Section 28, but we knew what was the commandant and the existence of IPID.
Would you agree with me, though, that it's not in the report itself?
But it doesn't change then. Even if you were to mention it now, it's not going to change anything.
In fact, what you say, if you would look at
Sorry,
bundle
Chair, might I
A-
ask?
Sorry.
Yeah, I just want to ask what the imputation is that is not contained in the report. I just want to make sure I understand.
Just repeat the question, Mr. Halley, because I also am not sure if I understood the question.
The argument, as I understand it, and it's an argument that is dealt with in the affidavit, understand what Mr. July is saying is that the defeat in the ends of justice emanates from the fact that the IPID officials, officials, have amended a report in circumstances where it doesn't express their honest belief. And what he said is that constitutes defeat in the ends of justice because that report is so important, and it's important as a matter of law. It's important because of the provisions of Section 28 of the IPID Act. It's important because of the regulations, and it's important because of the standard operating procedure. Those factors are all legal factors which demonstrate why that report is so important. What the proposition that I put in is that when I go through the Werksmans report, I don't see that argument being raised here. In fact, there's a different reason being given as to why it constitutes defeat in the ends of justice. So that's the proposition.
Now, that may be an important issue to raise, maybe with regard to whether the conclusions, recommendations they reached were correct or justified, isn't it? But the question is whether it takes us
No, of
to,
course.
yeah, it takes us to the kind of issues we are looking at.
Well, I want to get onto the reasons that are given over here. I just want to confirm that I understand correctly that it's not in the report, because I don't want to be unfair to the witness.
Yes, okay.
Thank you, Mr. Chair.
Mr. July, is
Chair-
it in the report,
Chair, we would
irrespective
not
of
have-
whether it should have been or shouldn't have been?
No, Chair, we would not have said, because of the importance of Section 28. No, we would not have said that.
So it is not.
Yes, we would not have said that. We would have said, of course, that there is an illegal rendition. The question is, who is responsible for that illegal rendition, which is an unlawful act? So if you protect those people, whether it's because of 28 or whatever, but you are defeating the ends of justice. Ends of justice meaning that people who commit unlawful act must be arrested. It has nothing to do with Section
Well, you said something much earlier about, you said something that I believed to be that you were saying your investigation was looking at whether prima facie
Yes,
somebody might
Yes.
be guilty of criminal offense or misconduct.
yes.
Which suggests to me that if what you are saying is reflected in your report, and I don't know if it is, but if it is, it would suggest to me that you were not saying conclusively they are guilty. That would be left to another process. You are saying on the basis of what you have found during the investigation, there seemed to be a case to answer.
That's exactly,
Is that correct?
That's exactly the
You
case.
were not going beyond that.
And in addition to that, Chair,
Yeah.
this is a recommendation to the Minister of Police. There
Yes.
should be no confusion here.
Yes,
It's a
yes.
Minister of Police,
Yeah.
not NPA.
Yes, yeah.
What NPA does
Yeah.
with the report, they must do their own
their
investigation
own, yeah.
and decide whether they
Yes.
want to prosecute or not.
So, am I right to say you are therefore saying whatever we make of your report and your investigation, we mustn't judge it and we mustn't judge you on a wrong basis? And the wrong basis being as if you were required to establish conclusively
Yes.
whether somebody was guilty or not guilty. You say we must remember that you were required to form a prima facie view whether there seemed to be a case for somebody to answer either criminally or in terms of disciplinary matters.
In both instances.
That's what you are saying.
And in both instances, Chair, it
Yeah.
was the case.
Yes.
Whether misconduct, people must go to disciplinary hearing.
Yeah.
Nobody was dismissed based on the report.
Yes,
No.
yes, yeah.
Nobody can be charged
Yes.
on the report and say, here's the evidence, it's
Yes.
this report.
Yes.
You can't do that.
Yes, but the point that I'm clarifying with you is that in effect you are reminding everybody that you were not the forum
No,
that would make
the decision.
fundings.
Yeah, no.
The decision you were seeking, you were looking at everything
Yes.
on a prima facie basis.
Prima facie basis. Yes.
Yes, which could mean once there was proper evidence, all evidence led, the situation could change.
Could change. Yeah.
And the people could be
Yes.
found not guilty.
Yes.
Yeah, okay.
Now, you had in fact had access to several prosecutors,
Yes.
amongst which were Advocate George Beloy,
Yes.
Advocate Mzanyati, if I recall correctly,
Yes.
Advocate Chauke, Advocate Mossing, Advocate Jiba.
I'm sorry, Mr. Harley. I just want us to have an idea of how far we might be going. Is it fine if I give you 15 minutes to try and wrap up? Or is that
A minimum of 30 minutes, if I can just put a series of propositions to the witness. So that-
Okay.
and then of
Try
course-
15. If not, I'll give you a little
Thank you,
bit.
Mr. Chair.
Yeah. Okay.
Would it be fair to say that of those advocates, those prosecutors who expressed an opinion on this issue, each of them made it clear that they have no regard at all to the reports insofar as they assess whether a crime has been committed or not?
No, not even a single one of them. All what I know, I spoke to Baloyi, and Baloyi makes a comment, Judge, and say, what I did when I looked at the docket, when it was sent to me, I started by just looking at the evidence. And from the evidence, I looked at the report. And then while looking at the report, I was then provided with another report, because it would seem the second report came after. And then he looked at the two reports. But he says, I've already formulated a view. But to say there was not a single prosecutor who said to me, we don't even look at the reports.
No,
Baloyi-
don't misunderstand it. So
Yes.
my question is, would it be correct to say that not a single prosecutor indicated that they look at the report to determine whether a crime has been committed?
No, I didn't ask that question.
No, I think,
ask
sorry,
that question.
maybe we speak it at cross purposes. I'm not asking you whether you had asked. What I'm asking you is a slightly different question. I'm asking you whether anyone had indicated to you that they considered the report in order to arrive at the conclusion that a crime had been committed. And I'm referring now, when I refer to the report, I'm referring, of course, to the IPID report.
You must remember, we were asking different prosecutors different questions. For instance, when we went to Chauke, starting with Mosing. Mosing is because he was involved in the investigation. So he would tell us everything about the investigation. That is one. So when we go to Chauke, it's because there's a memo by Mosing to Chauke, right? When we spoke we spoke about the memo to Chauke. When we asked Chauke, now that you received the docket, what happened with the docket? He says, I looked at the docket, but I must be honest, I didn't even read it. I handed over to Mr. Van Zyl. And Mr. Van Zyl, we spoke to Mr. Van Zyl over the phone. Mr. Van Zyl explained to us that even before I could look at the docket, these two guys came and say they want a docket and they will bring it back. I then gave them the docket. So those are the kinds of questions in those prosecutors. Nomgcobo Jiba, all what we asked was to confirm, did you receive the memo from Mosing? She confirmed. The meeting with Nomgcobo did not even take 5 minutes. Not even an hour with all these prosecutors that we're talking about, except, of course, Mosing. So we then went to Pretoria to meet with Zinyati and Baloyi. In that meeting, the issue of looking and not looking, only in that meeting where the issue of looking at the report was said, but there's a context in that. He was saying, I did not look at the report first. I first looked at the evidence. That's what I said.
Could I ask you to turn with me to bundle LEA 3? Chair, this is part of the This is part of it's an annex to the affidavit of Mr. July.
Yep.
If you would turn with me to page 1052.
Oh, unless 1052.
1052.
Yep.
Now, this is an interview, or this is a transcript of an interview between yourself and Mr. George Boloy and Mr. Sibongile Mzanyati.
Yes.
And there are a number of people that are present from Werksmans, including you, including Miss Kerry Badal, Mr. Sandile Tom, and Mr. Kwazi Utelezi. Is that correct?
Yep.
Now, if you would turn with me to page 1074. I'd like you to read from line 15 of that particular page.
The one which starts
I
with,
must say. Yes.
I must say from the beginning, when I received the docket, as the DPP mentioned, it had this email report. No, it has this email report, the second report. But I never had a look at the report, and I mentioned to the DPP that I might be taking a radical view. There is so much made about the first and the second report, but I do not look at the reports. That's not evidence. When I read the docket, I'm looking for admissible evidence.
No, sorry, let me just change that.
Evidence. Yes.
Not when he says, when I read the docket,
Yes.
I'm looking for admissible evidence.
Yes.
These reports are not evidence, he says.
Yes.
So he's talking about, generally, he says, when I read
Yes.
reports, I do not look at, when I read dockets, I do not look at reports. He goes on to say that the report itself is not evidence. Now, what you refer to as the semantic argument is actually not a semantic argument, because the report itself is not evidence. Would
No,
that be
it's
fair?
not. I don't dispute that. I've
Very
never
well.
said evidence, the report is evidence. All I can say is that the report is produced in terms of Section 28, and it cannot be ignored.
And so if you would turn with me to page 170 of bundle LEA1. This is where the Werksmans
I'm sorry,
report is
please
located.
don't forget your question, Mr. Halley.
Thank you, Mr.
Don't
Chair.
forget your question. I'm just picking up on this.
LEA,
Don't forget what you were
We'll-
looking for also, Mr. July. Don't forget what you were looking
Yes,
for,
yes.
because I'm interrupting you.
okay.
You see, the report is there, but Mr. Baloyi must be right that you can't say as a prosecutor, I've made my decision on the basis of this report. So for purposes of court proceedings,
Yes.
it doesn't mean anything, the report. What matters is the evidence. The report may be convenient,
Yes.
may be convenient to the prosecutors in that before maybe you go to the statements, it gives you an idea of what to expect in the statements. But in the end, you will go to the statements and your decision will be based on that. I think we are together on that.
No, there we are together.
Yes,
but
yes.
this specific docket and report,
Yeah.
it has got a history.
Yes.
When you receive this document, you are asked by the NDPP to look from the document with a history of it. It has gone to Gauteng. It comes back to, it goes back to IPT. When it goes back to IPT, it doesn't go back to Gauteng. It goes back to the national office. And then the national office takes it to where it does not belong in the first place, but is asking for recommendations. So that is the history. So
Yes.
ordinarily, I don't know how he operates, but he
Yes.
says, this one, he looked, because he knows the history, he looked at it. There's a specific reason why it's given to them. And there's a reason why they don't make a decision, they make a recommendation.
Yes.
Yes.
But
in principle, I agree with you,
yes,
General,
yes,
what
yes.
you are saying.
And maybe Mr. Halley was going to that point as well.
Thank you, Mr. Chair.
Namely, if one accepts that, it's that the prosecutor will base his decision or her decision on the statements, then it seems to me that the idea of the IPED investigator defeating the ends of justice by how he or she summarizes her report or analyzes loses more force. Yeah, okay.
Thank you, Mr. Chair. In fact, as I was referring to you to, sir, at page 170 of bundle LEA 1, this,
I'm
Mr.
trying
Chair, is
to look for,
I'm sorry, I think Mr. July is looking for something.
I think it's trying to find LEA 1.
can't seem
It's the same bundle as Mr.
Somebody must help Mr. July.
oh, I've got it. I found it.
You found it?
I found it.
Okay, okay.
Thank you, Mr. Chair.
How knows?
If you would turn with me, sir, to page 170,
One,
170 of that bundle.
170.
That is correct, Mr. Chair. This is Exhibit 8A, and it's your Werksmans report.
yep.
Now, paragraph 5.1.7, sorry, have you got it, sir?
Yep. I do.
You say each of the co-signatories to the second report deny effect in the deletions. We are of the view that the deletion of material evidence which is likely to affect the decision of the NPA in determining whether or not certain individuals should be prosecuted is a criminal offense, and specifically defeating the ends of justice or obstructing the administration of justice. Now, you've been told by Mr. Beloy that this is not evidence. We, generally speaking, I don't look at the report in order to decide whether a crime has been committed. I look at the report afterwards. In fact, what you convey in 5.1.7 is exactly the opposite of what Mr. Beloy has told you.
Can I explain that, Chair? The same reason why that report had to be collected. Otherwise, if those reports had no influence, Brad could have just left that report there because they are going to read the evidence.
Well, it might not be, it might be a question of how we put it.
Yeah.
I think we are all agreed that we are agreed about certain things. One is that it would not be proper for a prosecutor to base his or her decision simply on a report.
Yeah.
That's point one. Point two, there would be nothing wrong if a prosecutor based his or her decision on the statements without reading the report.
Yes.
There would be nothing wrong with that
Yes.
either.
Yeah.
Three, but a prosecutor may we would be agreed also about this, may, in addition to studying the statements, also study the report. Okay? What I am not sure about, and this is where you might come in, is whether one can go okay, let me put it this way. I'm not sure what else one can put in this equation. The context for this remark I'm making is your statement earlier that the NPA can't, I think as I understood you, you must tell me if I'm wrong, can't just ignore the report. Now, but of course, if we say, as I think we have all agreed, a prosecutor who makes his or her decision on the basis of the statements without the reading the report would not be doing anything wrong.
Yes.
If we accept that, that necessarily means he or she can ignore the report.
No.
So I'm saying I'm not sure that one can say there's nothing wrong if he looks at the statements only and still be able to say, but he must look at the report. The two are in
Chair,
conflict. Yeah.
yes, they sound mutually exclusive.
Yes, yes.
But they're not.
Yeah, okay.
They are not mutually
They are-
exclusive.
they are.
They're not looking at the report, as I understand, is not ignoring it at all.
I'm sorry?
By not looking at the report, I don't mean that you just not even look at all.
Yes.
You may look at it for the purposes of confirming
Yeah.
whether your view
Yeah.
is correct.
Yes.
And at the same breath, in the same breath, that report, what he has just read, Mr. Hadi, the evidence, the report itself, it's not evidence. But what is contained in the report might be material evidence, what you are saying. For instance, I put a statement which is said by Madilongwe. That report is not material evidence. But what I'm saying about Madilongwe is material.
Well, let's look at what the report is supposed to contain.
Yes.
To the extent that the report seeks to summarize the evidence in the statements, to the extent that the report seeks to analyze that evidence, and it seeks to make a recommendation based on the summary of the statements and the analysis of the statements, it seems to me that you would lose nothing as a prosecutor if you studied the statements thoroughly and arrived at your decision, okay? It may be that when you have arrived at your decision and you have more time, you'll take the report, you say, oh, it was also it arrived at the same conclusion as me, so it's fine, you know. But if in the report you have something that doesn't seek to summarize or analyze the contents of statements, but seeks to tell the NPA something else, that might be different. But then that something else, I would imagine, would not be of any legal importance if it is not evidence. But if it is evidence, even if it's evidence by the investigator, then it would be. So it seems to me that we might be able to agree that insofar as the report seeks only to summarize the contents of statements and to analyze the contents of those statements and come up with a recommendation. A prosecutor who doesn't look at it, but studies the statements properly and thoroughly and makes a decision, is likely to do his or her job properly. But it may be that it's advisable to have a look at the report.
But how would the prosecutor then, Chair, comes to the conclusion that I agree or I do not agree with the report? I know that the decision is theirs, but that person must be in a position to say, I don't agree with the report.
But
How do you do that?
But is there a law, is there a requirement that the prosecutor must indicate whether he or she agrees with the report?
No.
Because if there is no requirement, then nobody, she's not required to do that. And it would seem to me, subject to what you might have to say, it would seem to me that the report might be helpful and may be very useful to a prosecutor who decides to read it. But if a prosecutor says, look, I have a lot of cases, I don't have time, I'll look at what really matters, I'll look at the statements, and I'll apply my mind properly and make my decision. As long as I make my decisions on the basis of the statements, I will be fine.
That, Chair, I understand.
Yes.
But now what do you do with the intention of the person who is preparing that report? I understand what you are saying.
Yeah.
But if my intention of changing the report is to influence you,
Yeah.
the fact that I did not succeed to influence you, you decided to ignore the report, does the intention go away?
No, I think you are now on another issue. I'm on a different one. I'm looking simply at the question of the value, the legal value of the report.
Yes.
So that's what I'm looking at, to say what is the legal significance or the significance in law of this report, and particularly in the light of the fact that we all agree that the prosecutor needs to base his or her decision on the statements. If he or she has had the benefit of the report before making the decision, that's fine. But as long as her decision or his decision is based on the statements, nobody could have a problem with that.
So you must also bear in mind that when we look at it, we are looking at it not from the angle that is not going to be read. We are looking at it from the intention of the person who is drafting the report. And I am not going to accept that a person who does not succeed in his attempts to make that influence simply because the prosecutor failed to read the report and therefore that person had no intention to defeat the end of justice.
Well, Mr. Hall, you might wish to look at this, take this further, but there is the question which I raised in the morning.
Yes.
To say it seems difficult to accept that if I know that before you make your decision, you will look at this file A, because you must make your decision on the basis of what is in file A.
Yes.
If I give you file B, that is supposed to be a summary or analysis of the contents of file A, and I change certain things not to be consistent with what is in file A, if I know that you will study file A, it seems difficult to think that I would think that I will successfully influence you because I know you are going to look at this. And when you look at this, you will see that I've not dealt with certain information.
We have not looked from that angle of success.
Yes.
Whether they will succeed or not. We looked at the whole conduct and the intention. And we found the intention there. Whether what they did, they believed in their minds that they were going to succeed. And whether indeed they succeeded, that's another issue. But at the time of changing the report, otherwise there's no reason. No reason for it.
I understand what you are saying, but don't you say when you look at his or his intention, that is now the investigator who does this, don't you accept that the fact that he knows you will, before you make a decision, you will look at file A and you will see exactly everything that, including whatever he might not have included in file B, does seem to weaken the force of the argument that says he had an intention to influence.
I accept that, Chair.
Yeah.
There are people who would go and steal even if they know that to get access there might be difficult.
Yes.
But they would go there in any event.
Yes.
With the hope that they are going to succeed.
Yeah. So
And if
in
they don't succeed, it doesn't change the crime.
So in other words,
That
you're
we had the
saying
intention.
that they might be taking their chances
They were taking chances.
in case the decision
What
maker
if the other
doesn't read the
what if
statements.
the other prosecutor did not look at the report?
Okay, thank you.
Thank you, Mr. Chair. If I can move on, because we've
Yes,
spent
I
much
see
time on
we
this.
are at 6 minutes to, but I know I've occupied Mr. July for quite some time.
If I can,
How much time do you think you need?
if I can just go through and put a series of propositions to Mr. July,
Yeah.
he can deal with the
Okay.
propositions, and then
Okay.
we could wrap up, Mr. Chair.
Okay.
As I look at your report, and I know that you've spent quite a bit of time analyzing the first report, analyzing the second report, and you've almost done, you've done a table where you've mirrored the two reports against each other in order to demonstrate how the two reports differ from each other.
Yes.
In deciding which of the two reports is the correct report, sorry, which of the two reports has come to the correct conclusion, understand that you come to the conclusion that the first report comes to the correct conclusion on the basis of the available information. Is that correct?
Yes.
And if I understand correctly, when doing that exercise, you went through, you simply looked at the summary or the report itself. You were not investigating or looking at that report and comparing it to what was contained in the docket.
No, we were.
Were you?
We also looked at the docket.
You did?
We had to look at the docket.
Yeah.
Chair, we were provided with the docket.
Yeah, okay.
So we had to look at the docket, which is why we also came to the conclusion in other respect to confirm. For instance, when you delete whether the success report were there, we'll go and look that no, these reports are here. Why is it reported that there was no success report? When there's physically there's a report, you go and delete where it says success report was sent to so-and-so. And then you delete that part. But the success report, when you look at them, there are emails, they are sent to so-and-so. But that part is deleted.
Now, when I went through your report, The one thing that struck me about the report is that the report appears to summarize, and I'm talking now about the Werksmans report, appears to summarize the first report in explaining why it is that the conclusion is correct. It doesn't appear to summarize the docket.
No,
Do I misunderstand that?
No, you're misunderstanding it. You need to go through the whole report.
Okay.
You need to go through the whole report. That report summarizes, we first start with what the report says. You also remember, Chair, the first report and the second report. That is why we come to the conclusion that there is no second report. In fact, what happened is the people amended the first report, which they deny that it existed, right? That's what we are saying.
Yeah.
So we looked at it
Yes.
and we say what he says, Kuba. But remember some of the things that are in Kuba's report. He repeated them when we interviewed him. Yes.
Yes, well, it's interesting that you just used the word amended.
Yes.
Because earlier on I wanted to put to you that maybe what happened was effectively that the first report was effectively amended.
Yeah.
So, which sounds more acceptable to me than the alteration and so on. But you must remember that in a way, when you amend, you alter. But
Chair.
somehow it seems to sound less strange than the
Yes.
idea of alteration, because alteration just seems to give me this physical alteration.
Two things.
Yeah.
In fact, I'm using amendment in relation to the recommendation.
Yes,
But in terms of deletion of information,
yes, yes.
that's another issue. When I'm
Yes.
talking about the amendment,
Don't speak too far from the mic.
when I talk about the amendment, Chair, I'm making reference to the recommendations.
Yes, 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 yes.
But in fact, there were deletions to justify the amendment.
You know, sometimes how these things sound in one's ear and in one's mind is very strange, because in the end, when you look at when you amend, you change. And when you delete something in a document, you effectively change in the sense that the document no longer has the same things that it had before.
Yes.
So.
But
yeah,
you would
no,
also
I
want to
understand
know,
you.
you will also want to know what is the justification for that
Yeah.
deletion.
Yeah,
Yes.
no, that's fine, yeah.
Just insofar as if I can move over to the offences that General Dramat and General Sabia, because obviously the allegation is also that the minister was, and that's the allegation that's been made by Mr. McBride, Mr. Sissoka, and Mr. Kuba, that in fact there was no wrongdoing on the part of General Dramat
Yes.
and General Sabia, and the evidence didn't support such a finding. And the suggestion is that by using Werksmans, the minister had in fact sought an opportunity to reinvent a case against the General Dramat and General Sabia, one that had already been found by IPIT to be to have been without merit. You're familiar with the argument. I'm talking about the argument of Mr. McBride, Sissoka, and Kuba.
Or that the minister wanted to use the Werksman's report.
Well, wanted to use Werksmans. He had appointed Werksmans in order to come up with a report that would have the effect of reinstituting. If I can take you back, just to give you some context. So there's this report which is dated the 22nd of January, which makes a finding. And as the theory goes, and I'm putting it as theory, the theory goes, that report would be sufficient if relied upon to get rid of General Dramat and General Sabia, because it comes to a particular conclusion. They would be suspended, and of course, pursuant to their suspension, the argument is that that General Mfulmezo can then move into General Dramat's position.
Oh,
You follow?
that we were not even interested.
Yes, you would
No,
not
I'm
know
not saying that
anything
you
about
can't.
that.
Yeah, no. I'm saying when we were given 2 reports, we were not interested.
Yeah.
What is it intended for?
And you would not
we
have
have-
been told,
Yes.
if
But
there was
whether-
such a purpose, you would not have been told about it anyway.
Yes,
Yeah.
yes.
I don't want to touch upon that necessarily, but the point is I'm trying to give you context as to why the case against General Dramat and General Sabia was so important. Now, of course, you come to the conclusion that there was sufficient information in the docket to show prima facie that they had committed the crime, that they had committed several crimes. I'm talking about General Dramat
That they
and
did
General
not.
Sabia. They had. You came to the conclusion.
Yes, that they
As
had
per-
committed.
Correct. That,
Oh,
that there was
yes.
sufficient information, prima facie.
Yes. No, that's true. That's true, Chair.
Yeah.
That's the conclusion that we reached.
Yes.
And you want to know why we reached that conclusion?
Well, I don't want to necessarily go through all of these things. I want to
Yes.
just take you through. Otherwise, if we were to do that, we would be here for another day.
No, but I think, no. I'm not talking about telling you blow by blow. I'm saying why, having said, after the analysis, said Sabia was not at Deep Sloot. We didn't, instead what we did, we agreed with the analysis. We said we are not going to say anything
Yes.
about the analysis.
Yeah.
Let's accept the analysis.
Yeah.
These 3 guys who say they sold Sabia is their own problem.
Yeah.
But what we then say, there's a responsibility here. There is no way that Sabia being a head of Tom's and having agreed to provide the personnel, and we have already had an evidence which is contained in the docket by Mr. Leon Fester, Miss Fester, I think it's Fester, saying
Still,
this Malulek was not longer reporting to me. He is my subordinate, but he was taking instructions from Sabia, right? And we also took into account, Chair, the fact that they went to Zimbabwe, they come to South Africa, the evidence by Madilongwe is still there. We then say, but the conclusion can't be right, because these people have to be held accountable. Whether they were physically, that's not our issue. We said they should be accountable. Chair, just to remind you, rendition has been declared one of the crime against humanity. It's an international thing. We are part of the Human Rights Declaration of Human Rights, Harare Declaration, and all these other declarations. We are part of that. And now, what happened is that in terms of rendition, you may not pinpoint this. Your soldiers, people who commit that, sometimes do that because of the instructions. Now, how do you hold people up there who are accountable? You look at their knowledge before and after. What we know is that before, it is not a coincidence that the people, the police of Zimbabwe came into the country. It's because there was an understanding that there will be that assistance, right? The second thing is now the sending of the photos that were sent to Sabia, and they were also sent to Dramat, right? Now, we concluded that, and there's an evidence which says Dramat came to a meeting where these people were congratulated. We considered all of that, and we said, because of that responsibility, the position that they occupy, there is no way that they did not know about this rendition. That's how we came to the conclusion that they should be accountable.
you see, as far as the photographs are concerned, the photographs were never sent, just to answer a few questions that you've raised, or issues that you've raised. Photographs were never actually sent to General Dramat. As I understand it,
To the
they were in
PA.
fact sent to his PA.
Yes.
And as I understand it, it was sent to his PA
Not
in
for
order
his
to, for the
PA.
purpose of printing it and to give it back to.
No.
Do I
That's not how we
misunderstand?
understood it. That's not how we understood it. It was not for the printing. Even if it was for the printing, why could they not print themselves? Maluleka and them. The fact of the matter, we had evidence that indeed he came to the meeting, but what was in dispute is what he said when he left the meeting. Whether indeed he said that meeting must not be talked about, that he was there. Because there were conflicting versions there. There's one who said, yes, he was there, but I don't know about this part where he said we must not talk about him having attended the meeting. That's the only thing. But insofar as us being told, not differently, that he was in that meeting, he knew about the presence, and not only that, there was a meeting of the 5th of November when the operation took place on the 5th in the early hours of the morning of the 6th. So that meeting is also not disputed. What is being disputed is the analysis then says, you don't know what was discussed in that meeting. But nobody says the Zimbabweans were not there. There is ample evidence that the Zimbabweans that operated there, there were Zimbabweans who met with Dramat in the office.
Tell me, Mr. July, maybe as a matter of interest, did you ever look into the question of why people in the position of General Dramat and Sibia would have wanted to be party to an illegal extradition of Zimbabweans when otherwise they could get Home Affairs to deal with them and then they could be extradited in a lawful way?
Yes. In fact, Chair, this issue is raised by the Zimbabweans in a meeting that they had on the 6th. They raised the issue that we have a problem with South African government. People who commit crime in Zimbabwe, when they run to South Africa, we don't get them
them
easy.
back.
They claim political asylum. That's one, right? So we have a problem with that. Not only that, Chair, you will remember, I'm not sure with the cases that we've quoted, where you, part of those judgments, that we cannot, even when we use extradition, extradite people of Zimbabwe or Botswana to those countries if the punishment is going to be capital punishment. We would seek undertakings as this country that those people will not be sentenced to death. So we will never, as this country, extradite a person who is going to be sentenced to death that side. But in this case, it was an agreement to hand them over. Here's the thing, what happened. Coincidentally, after that meeting, in September, a superintendent was killed. They desperately wanted to get this superintendent. And it is stated that much in the success report. It's not something that we dream up. Maluleka says that in the report.
Okay.
It's not what we think. Yes.
Yes,
Now,
Mr. Harry.
thank you, Mr. Chair. The
We're at
important
10
thing-
past 4.
If I can just have a few more minutes just to wrap up, Mr.
Yeah.
Chair. Just quickly to deal with some of the things
Yes.
and to correct some of the propositions that you might have made earlier on. It's important that you make the point now that in September of 2010, that's when the Zimbabwean superintendent was apparently killed.
Yeah.
This operation, in fact, took place in November and possibly in the following year of 2010 into 2011, correct? But the meeting between Mr. Dramat, or General Dramat, and the Zimbabwean officials was on the 6th of August, 5th and 6th of August. The proposition that you've advanced is that the purpose of that meeting, if I understood correctly, you were accepting the proposition that the purpose of that meeting was to get hold of Zimbabwean criminals in relation to that crime.
You got me
Did
wrong.
I misunderstand you?
No, you misunderstood me. I'm saying they were talking about fugitives in general in that meeting of the 6th. It was about fugitives in general, coincidentally, which it so happened that the superintendent was killed in September. And in that meeting, they agreed that in 3 months, they must get together. And that a person was from both sides, 2 people were appointed to coordinate this issue. So when they came here, it was exactly 3 months based on the meeting. But at the same time, they've got this superintendent who was killed. That's all I can say.
Carry on.
No, I'm finished.
Sorry, complete what?
No, I'm not finished.
Sorry. And as I understand it, the success report, if you would turn with me to bundle LEA 14,
Yep.
the success report, as I understand it, was sent to several people. Is that correct?
It was sent to several people, including Raman. That's how they do it.
Yes. And do you recall who the other people were that it was sent to?
I can't recall.
Okay.
I can't recall. We can go there.
If you would turn with me to page, I've got it down over here as 1,300.
At 25 past, I'll stop you.
Thank you, Mr. Chair.
Yeah.
So
Page?
just bear with me, I seem to have the wrong, the wrong document. If you just bear with me. It's in fact in bundle LEA 13, Mr. Chair.
13.
That's right, my apologies. If I recall correctly, that success report had been sent to, amongst others, to General Labia as well. Recall that?
Page, what page are you?
I'm looking for page 1,329.
Okay, yeah, we can talk about it, I know.
But
I looked at the document.
My pagination system seems to have gone out. Don't worry about that. But you recall that it was sent to General Labia as well. Now, my recollection is that you didn't make a recommendation that General Labia should be charged.
Are you sure?
And we tried to...
Are you sure about that?
That's my recollection, but correct me if I'm wrong.
You can remind yourself that the report does say that. Notwithstanding that Libya says, this is how we receive, I would have written noted, because that's what I do. But it doesn't mean that, but we said he must be charged.
Okay.
And that's a prima facie view that we have. Whether NPA charges or not,
Yes.
it's up to them. And if they charge, they must know their story.
Okay. Then, and for the sake of speeding up this thing, I'm not going to go through that for the present purposes. If you consider the different the different reports, for instance, the photographs, there was no evidence that, as a fact, General Dramat received the document. And if I recall correctly, there's no recommendation at all that the secretary or the PA should be investigated, a statement obtained further, or anything to that effect.
We
Do I recall
can,
correctly?
for the purposes of that argument, we can just remove the issue of the photographs there. Would our recommendation stand? Yes. Knowledge, that's all what we're saying. Knowledge. And we state out why we said he was aware of this. That's all what to say. We might have been wrong that that meeting, which was held on the 5th, and on that very same day, and Law Enforcement has also made an affidavit, which is in the document, where he says, I came back with other people from an ATM bombing somewhere around 12 midnight. When I get to the office, there were cars, a lot of cars. That office that is talking about is the office of General Dramat. So,
Sorry, so
the
what is
point
your
that I'm trying to make, I'm answering the issue of knowledge. Knowledge is not about photographs. It's not about photos.
But what we're concerned with is not knowledge that an operation had been conducted,
Yes.
but rather the knowledge that the operation was an unlawful one.
No, it was unlawful. It starts.
And we're not asking whether it was unlawful, if you don't mind. We're
No, if
talking
it-
about whether there was knowledge that it was unlawful.
No.
That's the point I'm referring to.
No. Chair, if the operation was a lawful operation, because you need first, for you to be able to implicate Dramat and them, you need to give the legal status of the rendition. It was unlawful. If you leave the statement of Madilongwe, how the Zimbabwean police get into the country was unlawful through the phone. You allow the police of Zimbabwe that you were seen to be in a meeting on the 5th to do the policing in the country, in South Africa. And people get arrested. And some of those people who got arrested are handed over. And again, the handing over happens, there's an allegation because it's confirmed by Home Affairs from Orlando police station, that these people were moved direct from Orlando straight to Beitbridge, right? So all what I'm saying is the whole transaction, the whole operation was unlawful, starting from the call that was made.
Thank you, Mr. Chair. Insofar as the unlawfulness of the entry into South Africa is concerned, I must confess I've never seen anybody say that before.
No.
You seem to, and it seems to be the first time that it's been said now, that there was a breach of the law just entering into the country. Just explain that to us.
So it's a mind-bending logic to say a person can come into the country through a call. When a person comes to this country, you produce documents that I am getting in here. I've got, we're using, I don't know what they use, his passport. Yes, that's all what we need, that your papers are in order. The reason why they had to enter into the manner in which they did, because they did not know that they must be they are in the country. That can be the only logical conclusion.
And I must confess I don't recall seeing a recommendation that crime had been committed of allowing people to unlawfully enter the country. I understand about unlawfully leaving the country.
No,
As part of the rendition.
we didn't have to say that, but we knew that you can't get into the country by a phone call.
So in effect, on the information that you gathered during the investigation, it was clear to you, is that what you are saying?
Yes, sir.
That the entry into South Africa by the Zimbabweans was illegal.
Was illegal.
And and I guess once the entry was illegal, maybe that also influenced the illegality of leaving the country.
That's
Because
exactly the case.
if you are going to make your departure from South Africa lawful, you've got to report yourself to the authorities. Okay.
Now, of course, there's, and I say this respectfully, there's nothing in any of the information, any of the statements, that demonstrates that the sole basis on which they obtained entry into the country was on the basis of the phone call. The various statements, as I understand it, correct me if I'm wrong, the various statements, as I understand it, are dealing with the question not of whether the person has committed the crime of unlawfully entering into the country, but rather with the question of the rendition and what happened, and the assaults and so forth. So what happens here and what happens going out. Nobody actually makes the point that they didn't present their passports.
The fact that we don't make that point doesn't mean that...
I'm sorry, the fact that?
The fact that we don't make that point doesn't mean that we did not consider the fact that you can't get into another country by making a phone call.
Yes.
We
but
considered that issue.
I think maybe Mr. Halley's point is a slightly different one. Namely, you were informed that a call was made to General Dramat, is that right?
Yes, it's in the record.
And that after that call, they were allowed to
Yes.
get in.
Yes.
But the question, to put it differently, is, do you know, as a matter of fact, that those Zimbabweans were not in possession of the necessary documentation to enter the country lawfully?
The logical conclusion, Chair, is based that I don't know as a matter of fact that they did not have. But what I do know, for them to get into the country, it was because of a call. And I don't understand people getting into a country because they phoned someone else.
No, that I understand. You see, it's important to make the distinction if you don't know as a matter of fact
Yes.
whether they did have the necessary papers, because, of course, you might recall the evidence, the details of the evidence better, because it may well be that entry into the country was not on the basis of the call, but they did have the documentation. I'm just saying it could be, but for them to make arrangements, certain arrangements, it might have been necessary to phone a particular person. But once you say, as you have said, that you don't know as a matter of fact whether they had the documentation, that makes the distinction. It could be that they did not have, but it could be that they had, or some of them had. Yeah.
Chair, Madilongwe even goes further and talk about when they return on the 8th of November.
Yeah.
It's not just the entry.
Yeah.
When they return, when they called him Madilongwe, so he says, right?
Yeah.
So he assisted them. And also he assisted Malulek to hand over these people to the Zimbabweans when they were out the side of the border. So it's not just a question of coming in.
In that event, if they did not have the documentation, it wouldn't mean that the border authorities actually colluded with either the Zimbabweans or General Dramat to achieve the crossing of these people from South Africa to Zimbabwe without the documentation, the necessary documentation, if they did not have the documentation.
Yes.
You agree?
In
other words, the border authorities, they were required to, say, produce the necessary documents.
Yes.
And these people, if they nevertheless crossed into South Africa without such documents and out of South Africa into Zimbabwe without such documents, there would have had to be some cooperation of some kind from the border authorities.
I agree with that,
Yeah.
Chair, because
Okay.
Martin Long, remember, is from that border.
Yeah.
He was sort of the guy who
Yeah.
assisted them.
Yeah, okay.
Thank you, Mr. Chair.
I know I took
Not at all.
some minutes, but we are at an end. I give you
Thank you,
1
Mr.
minute to wrap up.
So effectively, and the reference to the email with the photographs, Mr. Chair, is at Y14A, that's Exhibit Y14A, it's part of Bundle LEA 11.
Yes.
And it's at page 439.
Yes.
We can consider it separately. What is clear, having regard to the different statements that were in the docket, it's clear that, and I'm talking now about the rendition docket, that the people who had implicated General Dramat and General Sabia were not in agreement, even although they were speaking about, in some instances, the same event. It was clear they were speaking about the same event, and at the same time, they were present at the same time. And yet, some mentioned that there was apparently that General Sabia was present and participated in the assault.
Yes,
Others
yes.
mentioned that he was present,
Yes.
but didn't mention that he participated in the assault, and others didn't even mention that he was present at all.
Which is the reason why, Chair, then, we did not even entertain the issue of assault. Because we concluded that, no, we don't think that we can agree with anything here. Let's leave as if General Sabia was not there.
Okay.
So the assault thing is not,
Yeah.
he was not charged for assault.
Okay.
And insofar as these...
That was the last question.
Thank you, Mr. Chair.
Yes, thank you. Mr. Waitobi, do you have re-examination?
Yes, Chair, I wonder
Do you have an idea how much time
how
you
much
need?
you would be willing to give me.
The re-examination is meant to be for clarification.
Yes, I
Yes.
intend only to clarify, Chair. I'm
Yes.
not going to waste time.
Yeah,
But I
okay,
just want to
all
know the maximum end.
Well,
maybe
I'm
let's-
hoping that you won't go beyond 5.
Yes, indeed.
Is that
I
fine?
definitely won't
Yes.
go beyond 5.
No, that's fine.
Thank you.
You can do it from there. I understand it's not comfortable when you
Yes,
are
I'm
there.
definitely not comfortable where I'm
Yeah.
standing. So perhaps I should then move across.
Yes, they'll sanitize and.
Mr. July, I want to start by, there's been a debate between you and the chair around whether or not the finding that you came to about the defeating or obstructing the ends of justice was a legitimate or not legitimate finding. I know the commission doesn't have to make a decision on that, but we have to test your own assessment. The definition, according to Batchel and Milton, of the crime of defeating the ends of justice is the following. It says, defeating or obstructing the course of justice consists in unlawfully doing an act which is intended to defeat or obstruct, and which does defeat or obstruct the due administration of justice. And then it continues, it is immaterial whether the alleged conduct has merely a tendency to defeat or obstruct the course of justice, or is even capable of defeating or obstructing the course of justice. Do you have any comment on that, particularly on the last part, that
Yes,
the
I
conduct
do.
does not have to
Yeah.
result, does not even have
Exactly.
to be capable?
Yes, I agree with that. I think that's exactly what I've been saying, that is, you look at the intention
Yes.
of the person, the outcome is something else.
But also the question of whether you are even capable.
Yes.
Thank you. Now, I want to then go back to the nature of your evidence. I only have 5 topics, Chair. The first one is on the illegality of the rendition.
Yes.
Now, my understanding of the issue of the illegality is that if you look at both reports, both the January and the March reports of Mr. Kuba, in both of those reports, he came to the conclusion that the rendition was illegal.
Yes.
Even in the final report of March, he still came to the conclusion the rendition was illegal.
Yes. Except that he says only one person.
No, I understand that, but the rendition itself as a practice that was
Yes.
undertaken was found to be illegal.
Yes.
The difference was whether or not Mr. Dramant and Mr. Sibiya should be held liable.
Yes.
Your analysis was that on the evidence that was before him, he should have concluded that they were also liable.
Yes.
On his version, certainly the second version, he found that they were not liable.
Yes.
Yes. Now, the reasons that he has cited why the rendition was an unlawful rendition, I just want to summarize them. They are contained, if you want to have a look at them, in the first report at page 477 to 482, and in the second report at page 522 to 553 to 560. Now, I want to summarize those reasons and see if you agree with them. The reason he said those were unlawful, one is because this was not an extradition.
Yes.
Number 2, South Africa had an agreement with the Zimbabwean government in relation to illegal immigrants in this country.
Yes.
Number 3, the officials of Home Affairs were not involved.
Yes.
Number 4, this amounted to kidnapping.
Yes.
Number 5, there was an attempt to hide what happened.
Yes.
Yes. Now, in the first report, he found that the people involved in these activities included Mr. Dramant and Mr. Sibiya.
Yes.
In the second report, he found it was only Mr. Maluleke.
Yes.
Now, this is really the point of your criticism. It is who was involved.
Yes.
Yes. Now, if we look then at your report, the reasons why you said Mr. Dramant was involved is contained at page 172. You can look at your own report.
Yep.
At 172, 173, 174, and 175.
Okay.
It is, it's called Exhibit Y8, Nkosi Nathi Nhleko. Nhleko. So the reasons why you came to the conclusion that Mr. Dramant was also involved starts at 172, 173, 174, and 175,
Yes.
correct?
Yes.
First reason, and this was debated with the evidence leader, the first reason that you give is his knowledge of the presence, in other words, the entry into the country. And that is what you give at 531511 of your report.
Yes.
It's the phone call.
Yep.
That's the first reason. So when it is put to you that the phone call issue makes no appearance in your report, that in fact is not accurate. Second reason is the 531512. There you refer to the success report.
Yes.
So he knows of their presence because that is the phone call, but he also knows of the success report.
Yes.
Both of those two, you then summarize at 173.
Yes.
And you say that if he knows of the presence and he knows of the report, he must take liability. And then, at the following page at 173, you explain again that he received communication during and after the commission of the rendition.
Yes.
So it's not only the entry, it is also as and when the rendition is occurring, which we've now established on their own version, it was an unlawful rendition.
Yes.
And then the second last reason is where you say he congratulated the members of crime intelligence. Yes. And then the last one is at 174, when you say he wrote a statement to the acting national commissioner of the police. And in that statement, he also confirmed his knowledge.
Yes.
Now, these 5 elements, they all appear on objective documentation, not necessarily on word of mouth. These are objective documents presented to you. In relation to Mr. Sibiya, the difference between you and the second report is that you say Mr. Sibiya should be held liable.
Yeah.
Now, here is where the distinction is, which sometimes it felt as if it was being overlooked in your cross-examination stroke evidence in chief. It is put to you that there is no evidence that Mr. Sibiya was present at the crime scene. You accept that there is no such evidence, or at least even if it exists, you didn't take it into account. Your reason.
I'm sorry, Mr. July. I think you are nodding, but there'll be no recording of your nodding.
In fact, Mr. July complained that Mr. Sosoko tended to nod.
So is he following suit now?
Yes,
Do you want to repeat
So let me
your answer
repeat the question.
Or repeat the
Remember
question?
that there was a debate about where exactly does the liability for Mr. Sibiya come in?
Yes.
One point that was put to you is about his presence at the crime scene.
Yes.
In other words, when the kidnapping is happening, right? Now, your case is you don't know whether he was present or not because the evidence on that score is contradictory.
Yes.
But you did not take that into account. What you did take into account is at 175. These are the reasons you gave.
Yes.
You looked at the reports to establish the prima facie case, and then you said he was head of Tom's unit.
Yes.
And that this is where it says, Sibiya stated as follows: the reality of the matter is that the operation in question was conducted under the auspices of DPCI, National Head Office, and they requested the services of my team because of their training and capacity.
Yep.
He himself acknowledges his knowledge.
Yes.
And then you say, this revelation by Sibiya confirms his knowledge of the operation that led to the rendition of Zimbabwean nationals. He provided Tom's personnel to assist DPCI to carry out the rendition.
Yes.
Now, did you need anything more than his own acknowledgement of his knowledge and the fact that he seconded employees?
No.
Yes. Now, if we sum up where we are on this evidence, is that you are faced with objective evidence of the involvement of Mr. Dramat, objective evidence of the involvement of Mr. Sibiya. And that is why you come to the conclusion that they should face the rep.
Yeah.
And none of these actually are disputed, even in your evidence in chief, what is being put to you. Now, in your report, how is this issue then dealt with? I want to move then, Mr. Chair, to the second element of my re-examination.
Yeah.
Which is how the writers of the second report deal with these key elements of the liability. And this, again, is contained in your report from page 147. So the first thing they do, which is page 147 at the top, page 34 at the bottom, the first thing they do is tampering with their recorder of the statement of Mr. Madilongwa. Remember that they first recorded the statement in full.
Yep.
And the next thing they do, they cut out, the clumsy cutting out of passages from that statement.
Yes.
And that you say at 147 and 148. So the portions that are cut out are the portions that implicate Mr. Sibiya and Mr. Dramat, which we have shown on the objective evidence. That's how you concluded. And the next is at 149. If you compare on the left and the right, we see precisely what has been cut out. The next is at 150 on the right. We see there, when it comes to the issue of the emails, it says on the left, which is the original report, it says the emails were sent to the PA of Dramat, Pumla, Zimbabwean police, and members of the crime intelligence. But in the portion that has now been cut out, the clumsy cutting out, what they say is he sent the email to the Zimbabwean police. The person that is omitted there is the PA of Mr. Dramat.
Yes.
But as an objective fact, that email was sent to the PA of Mr. Dramat. And then the same appears in the following section, where under the underlined portions, you say the letter was generated the same day, indicating in August 2010, General Sibiya and General Dramat went to Zimbabwe. You compare that with the clumsy cutting out. It says, this letter was generated the same day indicating the trip to Zimbabwe to discuss matters of cooperation. You see the cutting out is Sibia and Mr. Dramat.
I'm so sorry, Mr. Chair.
All right, sorry.
And obviously, sorry, I just want to raise not an objection per se, but as I understand it, my learned friend ought to be re-examining, which should be to seek clarity. Not sure if he's seeking clarity or merely reading and summarizing what is contained in the report of Werksmans.
Okay.
Thank you. I will take that.
Yeah.
No, I take the
point.
statement
Yes.
into account. Now, the same appears at page 151, 152, 153, 154. It goes on and on until the last is at 158. But the theme is the same, isn't it?
Yes.
It is taking out the evidence in the statement and then putting the evidence that removes those references. So that is what you said in your report.
Yes, that's exactly what. Can I just add
Yes, please.
and say, before we were instructed, and I mean instruction in the legal sense, not being told,
Yeah.
not being told what
Yes,
to do.
yeah.
Yes,
Before
because that has to be very
you're
clear.
given the brief.
Because what happened is that there was, unbeknown to us, it's something that we picked up now. Helen Suzman Foundation produced a similar report. We don't know for what purpose, but it's an article which was written on the 26th of February 2015. We were instructed on the 23rd of February. If you look, Chair, in that report, it does exactly the same thing that we did. But at that time, we didn't know that there was such an article.
Is that report in the bundle or is it?
It's not in the bundle,
or-
Chair. It's not in the bundle.
Okay.
It's something
It's
that
some-
we just
you-
came across it,
Oh.
and it has a link, and it talks exactly about the two reports.
Yes.
Yes.
If it's something you would like to make available to the commission, you may do so either now through your counsel or later on you can send it to the
Yes.
to
We will
the
send it.
evidence leader. Yeah.
Yes.
Thank you, Mr. Chair. If I then go to my third topic, we've now seen the illegality of the rendition and the clumsy cutting out of names in the so-called second report. We then come to the issue. Remember that there was a discussion that you had with the chair and the evidence leader about whether or not this was consequential at all. The fact that the second report removed information from the first report. There was even a suggestion that the report itself is not evidence.
Yes.
Now, of course, we need to clarify this a little bit. My understanding is that a report may be evidence if it records the observations of the writer from his own personal interactions. But it may also contain secondary evidence, which is sometimes called hearsay,
Hearsay.
where they say, I'm recording something else that was said to me. So it's not as if a piece of paper that contains a report is always not evidence. Good.
I agree.
Now, in relation to this particular report, its significance is, in fact, you remember that it was put to you that you were told by Mr. Baloyi or Advocate Baloyi that, in general, we don't look into these IPID reports. But what I want you to explain to the chair is the specificity of this particular report, how it happened. Now, I want to show you where it's dealt with. It is in the evidence of Mr. Mossing,
Yes.
who testified before you.
Yes.
At the particular paragraphs are at page 982. They start at 982, 983, 984. I want to go through those paragraphs about what he said in relation to this report and why, on these facts, this was a consequential report.
Yeah. 982.
982. It's marked as volume 2, so I don't know if that makes any difference to you. But it is the transcript of your meeting with Mr. Mossing.
Is it on the same bundle?
Yes, it is.
In the same bundle?
Same bundle, Chair.
Then if you tell me the red number right at the top.
Yes,
on the
the
page.
number at the top is Y8NPN0982.
0982.
82, yes,
Oh,
Chair.
that means it's page 982.
Yes.
No, it won't be in the same bundle that I'm having in front of me. Do you think by listening and just noting where it is in the bundles, I should be able to follow?
Indeed,
Yeah,
Chair, and
okay.
I also hope to do this third part
Okay.
quite quickly.
Okay,
Yes,
proceed. Yeah.
thank you. Now, the first thing that Mr. Mossing says, because he, in this portion, is asked specifically, why was this report important? And why were the alterations consequential? That was your question. But for him, why was this report important? He says, yes, they recommend, now he's talking about the recommendation of the January 2014 report. But I'm saying our role in the matter, we made it clear to them. In other words, they made, Mossing from the NPA side, made it clear to Kuba from the IPIC side, that this report is not given to me so that I can make a decision. We would submit it to the relevant DPP office, who would take it, and we were merely guiding that investigation and assisting them. As I said, we had continuous discussions with the investigation team. So at no stage did he disagree really as to what was happening. So the first thing I want to put to you there for your comment is that Mr. Kuba knows that this report is being prepared for submission to the DPP.
Yes.
It is not a report that is being prepared in order to be filed away. What will the DPP do about it? And then he continues. Says, I think there was a lot of pressure as well as to terminate the investigation to move over to arrest. We basically had to say, make your investigation complete first, make sure you've got all the evidence, which at least indicates a prima facie case so that a prosecutor can take it forward and at least is assured of getting a conviction.
Yes.
Do you want to comment on this?
Chair, what is important about that is Kuba claims that the first report was not a final report.
Yes.
But he was there in February to demand the arrest
Yes.
on the basis of that report. So that's very critical because you can't demand arrest on the basis of the so-called provisional and or a preliminary report or a draft report.
Yes. Good. Now, if you look at the following page at 984, Mossing continues giving you the evidence. He says, based on this report, which we understood to be the final report, with the investigation being final, as far as we were concerned, the matter was now ready to be submitted to a prosecutor to make a decision on whether to prosecute anyone or not. Billy Moeletsi and myself drafted a memorandum to the Deputy National Director of Public Prosecutions, Advocate Jiba, attaching, let me just say, get to that report first of all.
Yes.
And then you asked, you prepared a memorandum to the Deputy National Director, and I think you were looking for it. And then he continues.
Yes.
So we know two things about what Mr. Mossing told you. One is that Mr. Kuba was told that we need this report so that we can act on it. Number two, Mr. Kuba also knows that once I submit my report, a decision will be made based on it. As a fact, what we know is that the NPA prepared a memorandum based on the recommendations and the findings and the assessment of the evidence of the report.
Yes.
So the idea somehow that this report can just be prepared for fun is not founded in relation to what happened here.
Yes.
And Mr. Kuba is put directly involved as knowing full well what will happen to his report.
Yes.
Yes. Now, yes. So now that is in relation to Mr. Kuba. I want to move on, Mr. Chair, to the fourth topic. Now, we've dealt with the rendition and the reasons you came to the conclusion that Mr. Sibiya and Mr. Dramat were involved, and the reason you criticized the clumsy cutting out and the fact that, in fact, the first report was regarded even by Mr. Kuba in discussion with Mr. Mosing as final. And in fact, they acted upon it. So we've covered that part. But you then continue to say that Mr. McBride, Mr. Sissoko, and Mr. Kuba should also take responsibility for this. Now, their responsibility, as I understand it, is not in relation to the rendition, per se, but it is in relation to the IPID report.
Conduct, yes.
So, first point, we've already made that point, is that the IPID report was consequential because it was the basis on which a prosecutorial decision was taken.
Yes.
It is not as if the prosecutors ignored it.
Yes.
As a fact, they looked at it and they based their memorandum on it.
Yes.
The second thing is Mr. Sissoko. Now, you remember that there is the whole thing about what exactly was Mr. Sissoko's role.
Yes.
Now, I want to take you to the evidence in relation to Mr. Kuba, what Mr. Kuba told you. You remember that portion, that Mr. Kuba, I want to find the Kuba testimony about how he put this whole thing to you. Yes, I've got this. So it's called here volume 3.
What is the number there?
It is 2291, the portion I want to refer you to. Yes. Now, look at the explanation that is given to you by Mr. Kuba. And I know that your evidence is that his explanation subsequently changed, etc. But let's look at what he said at the interview. So we know that Mosing has told you this is a very important report. In fact, we took a prosecutorial decision based on it.
Yes.
2291 in the middle at 15.
Yes.
15 is on the right. It's line 15, and it's got McBride.
Yep.
He says, this is where he's summarizing. You've asked him a question. If Mr. McBride had not arrived, would you have changed it? He says, if Mr. McBride did not join, would it have been changed? My view, without even being convinced by Sissoko, I would not have changed it.
Yes.
This is Kuba telling you that his view would not have changed it. It's Mr. McBride's presence that influenced the change. And then he continues, because my understanding is that when we deal with such people, they are very senior, and to get a little thing where you can point fingers at them is not, because it means you won't get anything. Now, the senior people you're talking about here is Mr. Dramat and Mr. Sibiya. He says, I cannot accuse senior people without evidence, but here I was so confident that I could accuse them. At page 2292...
Mr. Chair, sorry, I think we've actually, it's got to the point where I need to now object.
Yes.
What's simply been put is a series of, not only of what the information actually contained in the document is, but also my learned friend's interpretation.
Yes, no,
of that
I was
document.
going to say, Mr. Ngwaitobi, put questions to the witness to clarify.
Thank you, Mr. Chair. Let's go back to the last question, because that seems to be the one that's causing the concern. Let's replay that question. So I've pointed out to you the portion where Mr. Kuba answers the question as what would have happened if it was not for Mr. McBride. And bearing in mind this answer, what is your answer? Yes, you can put in your own words, not in mine.
Chair, you will recall I did say this without even looking at the record, that I did ask Mr. Kuba, would he have changed the report? He said no, he would not have changed it.
Yes. And was that evidence that he gave you at the interview?
Yes, that's the evidence he gave at the interview
Yes.
of the 13th of April, 2015.
Now, you remember also that there was the question as to how, in fact, the changes were made.
Yes.
Now, this is dealt with at 2294.
Yes.
Now, at 2294, after line 15,
Yep.
this is where he explains how the changes happened. He says, he read it extensively, talking about Mr. McBride. Then the progress which I was doing on the report itself, I was only adding stuff. He was sitting next to me, I was adding things. I was doing things, but whether that part was cut out by him or by me, I will not say, but I don't remember removing it. And you say, deleting it. And then he says, no, no, no. I do not remember thinking to say, I'm deleting this part, because I had nothing to benefit by it. In fact, it's something that would have made me feel bad to have investigation and to make me have sleepless nights, and yet not all the things are going into that. But the way we worked on that report, I emailed it to Mr. Sissoko. I do not know how Mr. Sissoko dispatched it to him.
Yes.
So you remember?
Mr. Sissoko then confirms that indeed, on the 4th of March 2014, he received the email from Cuba, he made a copy, and then he gave it to McBride.
Yes. But in relation to the way in which the changes were made, you remember that the answer you had given in your evidence earlier was that Mr. Kuba himself told you that he did not know how these changes were.
Yes, no, he did. He said he didn't know. The only part that he made mention of was the analysis. The other deletions, he doesn't know about that.
Yes, all right. Chair, thank you. I'm now into my last topic. You will be very pleased.
Yes, no, I'm pleased. It's been a long day.
Thank you, Chair. Now, you remember that I want to come back now to the summary of how you concluded that a case had been made for defeating the ends of justice. Now, we know as a fact what the NPA did with your report, because we know that from Mr. Mosing.
Yes.
Yes. Now, my understanding of this, what you were criticized about, is that in your report, you did not mention the regulations, the Act, and the standard operating procedure. Can I ask you to look at your own terms of reference? I mean, because my understanding is that you were appointed under specific terms of reference.
Yes.
Which is at page 118, I think it's 118, if I'm not mistaken. No, 118 at the top.
Yes. Yep.
And there are 5 items.
Yes.
And were you asked anything there to look at regulations, standard operating procedures? No. And did you answer those terms of reference?
Yes, we did. In fact, we did look at all those instruments.
Yes, yes, yes. So the mere fact that they are not expressly referenced does not mean you didn't look into. And then in sum, what were the reasons why you believed that a prima facie, on the basis of what we have looked at the definition under in Milton and Butcher, what were the reasons for the conclusion you came to?
Yes. Chair, like it was indicated, it starts with what Mr. Ngubetobe referred to as a clumsy deletion of the information. The second one is start with the various reasons, excuses that are being given as to why the report was changed. One, Mr. McBride starts by saying he doesn't know anything about the report, but there is ample evidence to demonstrate that he knew about the report. So his denial of knowledge about the report, he says, all what I did was to do grammatical errors. I changed grammatical mistakes from the report. But we know Kuba does say, when we met with him, if there's any person who read that report extensively, is Mr. McBride. And we know that that report was emailed to him. It's confirmed by Sissoko, it's confirmed by Kuba that he did email. They did email. And so there's also another issue that you deliberately ignore the regulations. You ignore the SOP, which is the standard operation procedure, because it is very clear. Chair, the head of investigations is Director Investigations. The only two people who signed the report, in the absence of the Director Investigations, it would be the provincial head. Kuba signed as the provincial head on the report. But if you look at the witness statements that he took and he signed, or he commissioned, he signs as a Director Investigations, right? So there was no role for Sissoko at all. It is a lie, and they come here, they tell you that Sissoko was head of investigation when Sissoko was a program manager. If you go to the SOPs, it sets out what are the functions of the executive director, what are the functions of the program manager. You won't see any approval of the report. The legislature decided to create independence within the IPID. They were protective of the investigation in such that they exclude the executive director because they don't want the executive director to influence the decision. On what basis do you sign an investigative report when you don't even conduct the investigation? Yes. It doesn't make sense.
Thank you.
So, yeah.
Third last question. You remember that one of the criticisms against the firm, Werksmans, is, according to Mr. McBride, that you cannot, as a minister, ask a private law firm to investigate an independent organ of state. What is your comment?
You see, Chair, I forgive Mr. McBride. He's not a lawyer. But I have a problem with when those things are being said, led by a lawyer, then they are not challenged. Because there are two branches of law. You've got the public law, you've got the private private law. Both laws, the branches of laws, they've got sub-branches. Those sub-branches would be, you've got civil and criminal. And employment issues fall under civil. So when the minister comes to me, I'm a labor lawyer. And that's all what I know. It's labor law. So when it comes to me and say, here is my employee, you must recall, Chair, that McBride was an employee of IPID and accountable to the minister. And the Constitutional Court does actually say that he is accountable to the minister, and accountability should not be equated to interference. So when he has to account to the minister, how does the minister take a decision to discipline McBride without satisfying himself as to what is happening with the two reports? The worst that you could have done was just to take the two reports and say, I'm dismissing you on the basis of the existence of the two reports. He would have been criticized. Now he comes to the law firm, which is Werksmans, and it happened to be me at Werksmans who does that, and he then acts on the basis of the advice given to him. I've never heard anything, because there was a suggestion here, which I had, that we were doing criminal investigation. We can't, even if we like to do that. There is no private law firm that can conduct a criminal investigation. So all what we did is an employer-employee relation that we were dealing with.
Second last question. We debated the issue of the status of the IPID report. We know what Mr. Mossing said, but Mr. Kuba also did not say these reports were inconsequential. In the affidavit, which is from it starts at page, I'll refer you to the relevant portion. It starts at page 1499. Sorry, Mr. Sissoko, not Mr. Kuba. Mr. Sissoko, his affidavit starts at 1499, but at 1520, he deals with the status of the IPID reports.
1499.
Yes, yes, that's where it starts, but the relevant portion is 1520,
Yes.
and particularly at 1521. Now here it says that the IPID reports have got two types of relevance.
Yes.
One is relevance to NPA. NPA is not bound, right? But nowhere does he say that NPA can disregard in the sense that
Yes.
they can simply not read it. And we know that in this particular instance, the NPA wanted it. But I want to take you to the second relevance, which is at page 14 paragraph 14.6. Here he says, from the above, it is clear that the legislature intended that the disciplinary recommendations of IP to SABS are enforceable and cannot be ignored.
Yeah.
Now, what do you say to this? Because your recommendation, if we looked at your terms of reference, was to make disciplinary recommendations, which are employment related, as well as civil or criminal recommendations. But on the disciplinary side, what do you say to this?
Chair, that's exactly what we did.
Yes.
We made recommendations. And it was up to the minister, even from us, to say, what do I do with these recommendations?
Yes. Now,
And
Mr.
he
July, I'm
acted.
trying to ask you about the binding nature
Of,
of the IPIT report to SABS for disciplinary purposes.
no, the binding nature, it is binding.
Yes.
It is binding. When they send a report to SARS, and a report which is signed by IP, they have to act on that.
So if,
Mr. Chair, if I could be of some assistance as well, I think if I understand the evidence of Mr. Sissoko correctly, what he's saying is that that first report never went to the minister. So there was no recommendation insofar as the first report is concerned in respect of disciplinary proceedings. And one can consider the report.
thank you, that is appreciated.
I think the question is about the binding nature, whether it's binding or not.
Yes,
Yeah.
precisely. Thank you, Chair. You've got the point exactly. I want to move on, Mr. July. There's no need to respond to the evidence leader. But if it is binding and there has been tampering and deletion,
Yes.
in the sense that you've recommended or the report has made findings against Mr. Sibiya and has made findings against Mr. Dramat, what are the consequences?
The consequence, if you
Mr. Chair, if I might, and I really do hate to interject. The point is that, which is what my fear was in the first place, the point is that the first report was never sent to the minister. It was sent to the National Director of Public, or rather to the NPA, and it didn't have a disciplinary recommendation. That's the only point I wish to make. That's the point.
Okay.
It is a wholly irrelevant point. Please answer, Mr. July. What are the consequences of removing information which makes findings against a particular employee?
It is a misconduct. And it's a misconduct which a person must be disciplined for. There must be consequences for that.
Final question. In the same affidavit of Mr. Sissoko, he summarizes why he believes that Werksmans is involved in state capture at page 1536, and it goes on to 1539.
Yes.
It starts with paragraph 17.1. There he talks about what Minister Nhleko wanted to achieve,
Yes.
correct? Did you have any meeting whatsoever with Mr. Nhleko to discuss anything of the sort?
I've never met Mr. Nhleko. Never met, never spoken to him. I don't know. I know of him. We have never met with Mr. Nhleko.
Did you just get a letter? Did you get a call from his staff to appoint you? How did you get the...
I got the instructions. They were in an envelope.
An envelope?
Yes.
Okay.
But I've never had a talk to Mr.
You have not even spoken to him?
Never spoken to him.
Yes.
But I must indicate, Chair, even if I spoke to Nhleko. Because when you get instructions from client, you must speak to client. There is nothing wrong
No,
in
there would be
speaking to
nothing wrong
client.
about
But
speaking,
what
yeah.
I'm not going to do is to change the facts to suit the outcome of Nhleko. What you must do when you criticize my report, you must look at the facts, not on the motive of Nhleko. Assuming he had his own motive,
Yeah.
I was dealing with the facts.
Yeah, yeah.
So it's neither here nor there whether I met with him, but I can categorically say
Yeah.
I've never met him.
Okay.
There was no reason in this case
Yeah.
to even meet with him.
Yeah,
They
you-
provided us with the
A clear
whole
brief.
report,
Yeah,
the docket, the two reports. It was up to us to deal with that report.
Yeah.
If there was a need for anything that we wanted from Nhleko, we would have consulted with him.
yeah, okay.
Yes.
Now, the criticism there is Mr. Nhleko has certain ulterior goals that he wants to achieve. You've explained what your answer is. Now, the time where your name features is at 1539, paragraph 17.7. Now, this is the bullet thing why Werksmans is accused of being involved in state capture.
1-5?
1539 at paragraph 17.7. Looking for the basis for why they say that Werksmans has done something wrong.
Yes.
This is what they say. The Werksmans report, authored by July, was used as a catalyst to achieve Minister Nhleko's goal of getting rid of us and replacing us with more compliant individuals.
Yeah.
This is the ultimate end point of state capture against Werksmans. What is your comment?
Chair, if Nhleko use my report or Werksman's report for his, I've been saying this thing throughout the day, for his ulterior motive, that has nothing
You have nothing to do with those motives.
with us.
Yeah.
And
You did what you were asked to do.
yes,
And
and
you-
again, not that I'm not a Nhleko spokesperson, but again, if Nhleko looks for information to get rid of people and he finds it, what must he do with it?
Yes. Now, Mr. July, my only concern is factually whether or not you had anything to do with the usage of your report subsequent to its production.
No, all what we did, we prepared the report for the purposes of the minister. What he does with it,
Yeah,
it's
Was
his.
none of
We're
your
never
business.
involved after
Yeah.
the submission of the report.
okay.
Chair, I want to thank you for the patience.
No, thank you, Mr. Ngwaitobi. You took a reasonable amount of time.
Thank you, Chair.
I have-
And that will be the end of my re-examination.
Thank you very much. I've got only one question arising out of this, Mr. July.
Yes.
I thought that during your evidence earlier, I thought I had understood you to say, to accept the proposition that the NPA is not bound by an iPad report, such as this one. But when your counsel asked you a question on the binding nature of such a report, I understood you to say it is binding. Did I understand you correctly?
The IPID, I'm not sure if the question was in relation to the IPID or the SAPS.
Oh, well,
It was binding.
well, you can clarify. I thought he was talking about,
No.
about an iPad report being binding.
Is an SAPS.
Yes.
The binding effect is in relation to the misconduct.
Or in relation to
Because
the
there are two-
misconduct,
yes.
not in relation to the
Not to the
criminal
criminal
part.
part, no.
Oh, okay. Okay, thank you. Thank you very much, Mr. July, for coming to give evidence. And thank you very much to your counsel and everybody. We have come to the end. It's 5:15, but I think we are done.
Thank you, Mr. Chair.
Thank you. On Monday, the commission will hear evidence relating to PRASA. Judge Makubele will be giving evidence with regard to at the time when she was chairperson of the board of PRASA. And then for the rest of the week, I will be hearing evidence relating to the Free State, Tuesday up to Friday. So I make this announcement for the public and the media about what is happening next week in the commission. We adjourn.
Thank you.